authority removed. Thereby, it may be, it cannot be any other day minor.
It is not in my assignment.
I give code number one rakhala old
One man is BP Satpati.
it is I get to matter housing.
I don't think so.
I made
Check.
Item 13 not placed.
Item of this list, supplementary list,
Supplementary list.
not first.
Item
13, 13.
30.
Oh, one.
Item 31.
31. Yes, item 31. Who's for the other side? Have you taken consent?
I am from the opposite party.
No, who's for the petitioner? Let the petitioner come. Let it reach.
Item 13.
Yes.
So, government file counter, I have requested to take copy of the counter.
You would have not placed one, right?
No, 13, say 30.
You filed your account. You have not served copy.
Yes.
I'm sorry that has not.
Let a
been
copy of the
served.
counter affidavit filed by the state be served upon counsel for the petitioner. Let this matter next week.
Right.
Yes. Yes.
Item 36. Notice was issued, but there is a noting that addressee could not be found. 36. May I be permitted to take fresh notice?
Let it reach. Let it reach.
Item 21.
No instructions.
No instruction disposed of.
Item 21, my lord.
Item?
Item 21.
Yes.
That is one 2 weeks after, my lord, due to illness of dependent 5, my lord. Suffering from brain stroke, my lord.
Item 21.
Again. Also,
WBC 5322 of 2024.
again.
Let's just matter 2 weeks after expiry.
My lord, 27. Next week.
All right. So 27 is 2017 matter.
My lord, last time notice for first time aschi. Instruction that phone पे लगी ना आज
Who's for the, you are for the petitioner?
हाँ my lord. 16 तक आसू तो कर देवी. Instruction खाली नहीं आसी केस टा अच्छी नहीं क्या ना.
Let's just matter on Friday. 16th. Yes.
So submitting the mentioning memo to call up for hearing next week.
Yes, yes.
Submitting the mentioning memo, call up for hearing next week.
I don't understand.
Lordship, the urgency is that the appellant has lost in both the counts.
So what is the matter? Second appeal.
Yes, Lord.
You wanted to be listed?
Yes.
Of which year?
2018.
All right, give the memo. Yes.
My lord, TRPC 196 by 2023. May you please fix a date for
Yes.
both parties have compromised their case. May you please fix a date for hearing.
File a memo. File a memo. Ask somebody to file a memo.
Yes, my lord.
Then we'll see.
Yes, my lord.
Yes.
List item number 1, fresh admission.
Infructuous. Dismissed as infructuous.
Item number 2.
This is TRP matter. Why should the petitioner?
Yes.
I wanted the petitioner which is pending at Kendrapada is to be
Transferred to Jajpur.
Jajpur.
All right, take notice.
Aye.
Issue notice by speed post. Fixing a short returnable date. Requisites be filed by tomorrow. Tomorrow, no, day after tomorrow.
Day after.
कल तक ठीक है जी. कल तक 14 तारीख है ना. By tomorrow.
So by Friday.
All right, by Friday. Place this matter on
24th September.
24th September.
Item number 3.
इसी बंद ही
May I please your lordships?
Yes.
Item number
So, the lady wants to transfer the CP number 42024 pending in Learned Family Judge Bhubaneswar to Family Judge Balaswar, my lord.
All right, notice.
My lord, the IA is there.
Notice, stay. 24th September.
Proposed.
Item number 4. May I agree? My lord, matter relating to selection of Shiksha of the year 2016. That while the petitioner while submitting online application, there are choice option given by her for 22 districts. In respect of 2 districts, she has been allowed. For the rest of the districts, she has not been allowed. that therefore your lordship has already delivered a judgment. That is in the case of Mamata Naik versus State of Odisha.
Yes.
And the petition is squarely covered by that.
But what about this order? Annexure 8?
Annexure 8,
Impugned order.
impugned order.
Impugned order.
My lord.
So let them consider?
In the light of that, Judge.
Yes. The petitioner claims engagement as Sikh pursuant to a notification dated 26/12/2016. It is a case that her candidature was considered only in respect of 2 districts of her preference, and thereafter the selection process was stopped. Her representation in this regard has been rejected by the Secretary to the Government and School and Mass Education Department by order dated 11/2020. So, it is submitted that the case of the petitioner is squarely covered by the ratio of a judgment rendered by this case, by the ratio of the judgment rendered by this case in the case of Mamata Naik versus State of Odisha, disposed of on 26/4/2024. So, considering the submissions as above, and without expressing any opinion on the merits of the claim of the petitioner, the writ application is disposed of, directing the Secretary of the School and Mass Education Department to consider the case of the petitioner in light of the judgment of this court in Mamata Naik Supra, without being influenced by his earlier order. Stop. A decision in this regard shall be taken within 2 months from the date of production of certified copy of this order by the petitioner. Yes.
Item number 5. On behalf of Mr. Jena, kindly pass on.
Pass out.
Item number 6, may I please, Your Lordship? My lord, the petitioner, who is the aspirant of the post of Anganwadi workers, has challenged the order under Annexure 6, in which, in appeal miscertificate case, the selection procedure was stayed by the Lord and Sub-Collector Rairakul.
No, this is Annexure 6. What happened? What is the fact?
37, my lord.
What is the fact?
Fact is that, my lord, during selection process, my lord, kindly see Annexure 1, the advertisement issued by the Anganwadi, my lord, CDPO,
Yes.
to fill up the post of mini Anganwadi worker for the post of my lord, against the Kainga village Anganwadi center, my lord, mini Anganwadi center, in which, pursuant to that advertisement, the petitioner as well as OP number 6 were applied for the said post, my lord.
Yes.
And in the said advertisement, the date was fixed for filing of objection was 22/2024 to 26/2024.
Yes.
During this period, the OP number 6 has never objected regarding residence of the present petitioner matter. Thereafter, after selection process is over, while going to issue the selection appointment letter, he has filed a
You were selected.
selection list was not published.
Okay.
During that period, apprehending she may not be considered for the post, he has filed a miscertificate case appeal before the appellate authority under the miscellaneous certificate rules, my lord, before the Sub-Collector Rairakul. In that proceeding, Sub-Collector himself is the chairman of the selection committee, my lord. He has stayed the selection procedure, my lord, last para, Annexure 6, page 37. Then start an appeal and asked Tahsildar Nagpur to submit the para-wise comment along with LCR bearing Miss certificate case number so and so on or before so and so. Also directed the CDPO Nagpur to stop the selection process of the Kainga till disposal of the appeal Miss certificate case.
Mr. Das, how can it happen?
It may be in favor of the petitioner.
Maybe, but he is, the sub-collector is exercising jurisdiction in two different fields.
Yes.
One is as the appellate authority under that miscellaneous certificate rules. How, being that authority, how can he stay the, proceeding selection?
He being the chairman of the selection committee might have thought it proper.
He cannot do that. He cannot pass any order in this case. In the selection, in that case, supposing there is an appeal has been filed, then he may.
Yes.
But no appeal has been filed.
No, he has filed an appeal.
No, he has filed an appeal here in mis certificate under the miscellaneous certificate rules. No appeal under the Anganwadi guidelines.
No.
So the Anganwadi proceeding can be stayed only in an appeal filed under the guidelines.
Yes.
Not under this provision. So,
But the sub-collector has exercised as it appears as the chairman
no, he cannot.
to await the final outcome in the residence.
No. He can pass this order, but in that other case,
Yes.
provided there is an occasion for it. There is an occasion for it. So, you take instructions.
It is for the petitioner now to get that process stayed till his certificate is decided.
Whoever, that supposing he has that other appellant who is before the sub-collector,
Yes.
he is challenging the resident certificate or whatever. What is he challenging?
Certificate of
Resident certificate. You are a resident certificate, obviously. So, both can proceed simultaneously because they operate entirely in different fields.
But this may be at the risk of the present petitioner.
Yes.
In case the selection proceeds, she may be in difficulty in case she is not selected for not being a resident of the area.
No, but will this be legally tenable? You take instructions. I'm calling it next week.
Sir.
London State Council shall take notice as regards the competence of the sub-collector to stay the selection process of mini Anganwadi worker while functioning as the appellate authority under the miscellaneous certificate rules. Let's this matter next week. Yes. What interim order do you want?
Further stay of further proceeding of the miscellaneous certificate.
That would be against your interest.
Yes. Next week, we will dispose of next week. Yes.
Item 7. The petitioner working is a Anganwadi helper, my lord.
Yes.
His date of retirement was 1/1/24, my lord.
1/1/24.
As per notification to Annexure 2, my lord, the divisional authority asks the petitioner to submit his willingness for continuance of further 2 years and with medical fitness certificate. Accordingly, petitioner submitted on 16/10. Letter issued on 1/10. Petitioner submitted 16/10. But my lord, the Annexure 4, they
No. When was the Annexure 2? This was issued in February 2019.
yes.
Guidelines.
Guidelines.
Provision will be applicable for those retiring from the month of January 2019. All right. Then
The petitioner is 1/1/24, my lord.
1/1/24. Yes.
They provide Annexure 1. The divisional authority asks the petitioner submit his willingness according to medical fitness certificate. And by Annexure 3, she submit her willingness and with medical fitness certificate. But the Annexure 4 was issued by the sub-collector on that was in belated state, that delay of 15 days, my lord. But till that the petitioner is continue, my lord. Annexure 6 is the letter of Anganwadi.
Just let us see what is Annexure 4. Willing to be re-engaged should give her willingness 2 months ahead of her superannuation to continue in service for a further period of 2 years. It means the applicant submitted related over that.
The Annexure 1 रे मतलब मागले 1/10 रे.
Got a minute.
ମୁଁ ଦେଲି 16/10 ରେ.
So that was rejected. Thereafter,
Yes.
what happened?
Petitioner is continue, my lord. And the Annexure 6 is the letter of Anganwadi worker. With the petitioner of helper, she wrote a letter to the CDPO that petitioner is continuing since then and his work is satisfactory. And she may be continue, my lord. But now, my lord, what happened? On date of filing, they are not allow the present petitioner. Since 9, not 3.
Yes.
Instruction are required.
learned state
And
council
nobody also appointment in place.
shall obtain instructions. And if necessary, file an affidavit in reply. Stop. Release this matter on third date of 3rd September.
I filed IA
आयर कौन होगा?
not to disengage. Which still is continue. In 9 तारीख
So you have yourself said that you have not been allowed to
allow
function.
କରୁନାହାନ୍ତି କିନ୍ତୁ ମୁଁ ଜାନୁଆରୀରୁ till 9 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ସେ and nobody is upon there is. ଆଉ
In the interim, it is directed that no other person shall be engaged as Anganwadi worker of Kapileswar to Anganwadi center.
Help.
Anganwadi helper of Kapileswar to Anganwadi center till the next date.
Next same another Anganwadi center.
Same.
Another Anganwadi center.
All right.
Same. 9 urgent copy.
Interception.
Dismissed as infractions.
I don't know 10.
Yesterday, when the mention was made, I agreed to remove this matter before your lordship. But I am not cured. I pray before your lordship.
16th?
Called next.
16th? 16th को नहीं जो? Yes. 16th बने शुक्रवार दिन.
शुक्रवार दिन 20 रहेगा ठीक है बात.
All right, notice.
But my only submission, my lord, it is a second appeal before lordship. But if it will argue just like a first appeal, it will take months together.
No. I have confined the second substantial question of law only to three questions, if I remember correctly. So,
ସେଇଟା ବି upload ହେଇନି ଟିକେ
कौन कौन ही नहीं उसमें कल कॉल अपलोड कर देते हैं.
Monday
देखो आज जिम थे लड़की मत लॉस ओवर देखियो करेक्शन कर देले से तो
आइए भी फाइल ହେଇଛି for status को ସେଇଟା ବି order କିଛି ହେଇନି
सेटा ये ही नथला.
ନାହିଁ.
But how much time will you take, sir? You have to conclude within 1 day.
I will try to conclude within 2 days.
1 day, sir, enough, sir.
ଅଛି ନା 11ଟା ପଏଣ୍ଟ
ସବୁ ପଏଣ୍ଟ କଣ ହବ ଏଠି?
ସବୁ ଆଜ୍ଞା ଅଛି କେସ୍ ଲ ଅଛି
I don't claim to know more civil law than you, sir.
No, but that
And probably between you both, nobody knows more civil law than both of you.
Yes. My young friend knows.
And of course you are there. I'm sorry, I forgot.
I'm far behind in comparison to them.
No. So I will request you to kindly confine your argument.
Yes, I will go so very short and specific.
Yes. So তাহলে Monday হবো ହେଲା.
Monday no 19 तारीख होची Monday.
I'm sorry.
20 तारीख मंगलवार.
সেটা উইক কমেন্সিং হবো 20 তারিখ কিন্তু it can okay 20 রে হোক কিন্তু
लिस्ट रही गले तळे हे जोडली भी टेकन अप 20 वीकली लिस्ट रो
नहीं 20 तारीख first there will be no court on 20th. Probably after lunch I will not sit. I have some work. I have to go outside. So 21st I will be on leave. So we'll take it up. I'll call it in the list, weekly list, with the understanding that on 20 तारीख যদি by chance न पड़ला 22 तारीख হবে. As requested by Sri Vidyadhar Mishra, learned senior counsel appearing for the appellant, list this matter on in the week commencing 20th August. Let it be in the weekly list. Understanding है या? And sir, my request is.
No, I will complete it within that week.
And Mr. Bag, my request is also stands for you. When you will reply.
My argument will be within 15 minutes probably.
No. What?
Item number 11.
Item 11, yes.
At the last order, the opposite party number 3 were
And on behalf of
Last order.
3, I have filed a letter giving the copy to other side.
You are appearing for the university. Deputy, I'm sorry.
Opposite party number 3, my lord. Mr. Nirmal.
এটা ଗୋଟେ open ended letter ইয়ার মানে কিছু নাই. This is no মানে it seems the university, the only technical university of the state is expressing helplessness. It says, hence you are requested to redress the grievance of Ravindranath Mahanti as early as possible. What is the meaning of this as early as possible? Under intimation to the university, failing which the university shall be constrained to de-affiliate the course, including non-grant of affiliation, de-recognition. 19/4 চিঠি গলানি. Last time to this was considered. My last order was
16/7.
yes 16/7. Yes, 19/4 letter was already referred to in the previous order. Why are you showing this? লেখা হয়েছিল যে on which date Mr. Rautra shall apprise the court as regards the steps taken. দেখি again this is also not 2 weeks has gone by. July 29 you write this letter asking the Krutika Institute to settle the issue, or else the university shall take necessary action for de-affiliation. I think 2 weeks have gone by. What action has been taken?
Not yet.
No. Your good name, madam? Your good name?
Sanjukta Patra.
Mrs. Sanjukta Patra appears on behalf of Sri N.R. Rautrai, counsel for BPUT, and produces copy of letter dated July 29, 2024, whereby the institute has once again been instructed to settle the issues within 2 weeks on the threat of issuance of necessary action for de-affiliation of the college as per rules. 2 weeks have elapsed in the meantime. It is learned counsel for the BPUT is unable to apprise the court as to what steps, what further developments have taken place. Stop. This presents a sorry state of affairs. List this matter on 16th August, on which date the BPUT shall come up with a definite stand as regards the action taken, if any, as regards the coercive action taken, if any, against the institute for non-compliance of its instructions. Yes. A copy of this order be handed over to Ms. Ponda for for necessary for doing the needful. Stop. You take copy of this order.
Yes.
Today you will receive copy from the order.
Yes.
And yes. Item 14. Item 14.
Yes, madam.
Item 12 ta? 12 oh chali gala. Asha 14.
This case, I am filing the rejoinder as well as the written submission.
12 was
12 ta adjourn hi.
12 ta administration dismissed.
In item 14.
Item 13 alerts. Item 13.
Item 13 ta kon hidela? Next week.
No instruction number power is.
No instruction. Item 13, no instruction. Disposal. No, he has filed a rejoinder.
Okay, I have served yesterday.
Well, this is the original rejoinder. This is a copy. This is a copy of the rejoinder.
Okay, I have served.
This is the original rejoinder.
Original.
Rejoinder kon court fee lage nahi? Rejoinder affidavit.
Affidavit.
Achha. Okay. Last page lage. Achha, have you received you want time or you can argue?
item 13.
Item 14.
Perhaps my friend must have received.
Just now he has soft copy.
So,
Yesterday I have.
You have soft copy yesterday. No, then. Yes, Mr. Das, let us take it up.
Sorry, your lordship,
the
I have to
counter affidavit has been filed.
Yeah, what a matter.
Extradited file already.
Yes, served a copy of rejoinder to you.
It was. Ashwini, it has not been tagged here. So basically,
Full case.
yes, yes, it is there at the front page. Yes,
Yes.
I'm sorry.
In this case, my lord, petitioner was
Learned counsel for the just to learn counsel for the petitioner files rejoinder in the court after serving copy on the state council. The rejoinder be kept on record. Yes.
my petitioner was initially appointed as Anganwadi worker for Sansad Anganwadi Center in the year 93. Since 93 to since 2009, she has worked for the satisfaction, utmost satisfaction of the authority concerned, my lord. In the year 2009, my lord, as per Annexure 1, one notice was issued against me that I have the irregularity in the duty. I have not distributed the foods. I have not also some other irregularities they have against me by the CTPO. On that basis, I have replied the as per Annexure 2. I have all the allegations purported to be. I have replied so far Annexure 2. Thereafter, my lord, what happened? In the Annexure 3, sub-collector was no authority to take up the matter, who is a chairman of the committee. He has to take up the matter, terminate me on the basis of Annexure 3. Thereafter, I went on appeal as per Annexure 5. The Annexure 5, the learned collector, after hearing the case, remanded back to the sub-collector for fresh consideration because opportunity was not given. Thereafter, my lord, Annexure 6, your lordship may kindly have a glance. Page 18. On the basis of Annexure 6, my lord, he has issued notice to me to appear, and in that case, he has also reflected there in that. Just last line, just I am placing, my lord. एणु तुमको जणाई दिया होछि कि अत्र कार्यालय आदेश संख्या 789 30/7/2009 रिख काहे कि बलवत्तर नहिबो तुम एही पत्र पाइबार 30 दिन बदले लिखित जवाब निकट दाखल करी. Thereafter, Annexure 7 was I filed before the sub-collector. That the sub-collector, without hearing me, my lord, he has disposed of the case. And
what do you mean by not hearing you? You are Anjali Biswala.
Yes, my lord.
The appellant Anjali Biswala, Anganwadi worker of Sansada, is present with her learned advocate.
Learned advocate. But I have that sub-collector, my lord, before the sub-collector.
Yes, Annexure 8.
Yes, my lord. It is observed that CTPO Palada file, I am just placing. Present with learned advocate had also produced the so-called file and so and so. And thereafter, Lord's may kindly have Annexure December para 22. He has passed the order, hence the previous order passed by 30/2009.
Let us read the entire array. The observed that CTPO Palada reported wrong subordinate concern regarding serious lapses. The official representation.
Just I am placing the.
Just let me read. To prefer appeal, challenge this order.
Yes, my lord.
You have to challenge this order.
Challenge this order. This order I have not challenged. Straightway I have filed this.
Why don't you challenge it?
Sub-collector.
This order can be appealed before the IDM.
No, I have filed against the collector.
You file an appeal again. No, initially it was remanded.
Initially it was remanded. Thereafter, sub-collector heard this matter and asked for show-cause. Show-cause was filed, but without hearing from me. Only advocate was present. Without hearing from me.
No, it is written you were present. You were present.
No, my lord, perhaps.
The appellant Anjali Biswal, comma, an Anganwadi worker of Samsoda Anganwadi Center is present with her learned advocate.
Yes, my lord. First line.
ଲେଖା ହେଇଛି ଆଉ କଣ ଆପଣ ଏହାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବେ ଆପିଲ ଫାଇଲ କରିବେ ଆଉ କଣ କରିବେ ଫାଇଲ ଆନ୍ ଆପିଲ 2012 ରୁ
Appeal file is.
ଫାଇଲ ହେଇଛି
Annexure 9.
ଆନେକ୍ସନ
The annexure 9, the collector also stand the previous order so far annexure 3 is concerned. Upheld that order annexure 3. And so far annexure 2 your lordship will finds the from the show cause. Just I'm placing the show cause matter. ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରଟି ସାନସୋଡା ଗ୍ରାମର କ୍ଲବ ଘରେ ପରିଚାଳିତ ହୋଇ ଆସୁଥିଲା। ଗତ ବର୍ଷ ଜାନୁଆରୀ ମାସ ଶେଷ ସପ୍ତାହ ବେଳକୁ କ୍ଲବ ଘର ଛାଡି ଅନ୍ୟତ୍ର ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରଟି ପରିଚାଳନା ପାଇଁ ପରାମର୍ଶ ହୋଇଥିଲା। ଗ୍ରାମବାସୀ କ୍ଲବ ଛାଡିବା ଘଟଣା
where is the show cause? What was the allegation against you?
This is my so-called
This is your reply. What was the show cause notice? Annexure 1.
annexure 4
ନା annexure 1 ରେ କଣ ଥିଲା?
annexure 1 ରେ ଥିଲା ଆପଣ ଏ ଦିନ ଭିତରେ ଦେବେ ବୋଲି
ସେଇଟା
ଆପଣଙ୍କ ଉପରେ
I would like to know what is the allegation against you?
only allegation.
What is that allegation, sir?
Allegation just are placing page 10 your lordships.
Yes.
ଆପଣ 15/2/2008 ରେ ଅଙ୍ଗନବାଡି କର୍ମଚାରୀ କେନ୍ଦ୍ରରେ ଆଉ କାର୍ଯ୍ୟ ତୁଲାଉ ନାହାନ୍ତି ଏଣୁ ଅନୁପସ୍ଥିତ ରହିଛନ୍ତି। କେନ୍ଦ୍ରରେ ସମନ୍ୱିତ ଶିଶୁ ବିକାଶ ଯୋଜନାର ସେବା ଗୁଡିକ ଯଥା ପରିପୂରକ ପୁଷ୍ଟିକର ଖାଦ୍ୟ ପ୍ରତିଷେଧକ ଟିକାଦାନ ସ୍ୱାସ୍ଥ୍ୟ ପରୀକ୍ଷା ପରାମର୍ଶ ସେବା ସ୍ୱାସ୍ଥ୍ୟ ଓ ପୁଷ୍ଟି ସମୟ ଶିକ୍ଷା ପ୍ରାକ୍ ବିଦ୍ୟାଳୟ ଶିକ୍ଷା ଯୋଗାଇ ଦେଉନାହିଁ। ପୁଷ୍ଟିହୀନ ଶିଶୁମାନଙ୍କର ପରାମର୍ଶ ସେବା ଚିକିତ୍ସା ବାବଦକୁ 1269 ଟଙ୍କା ଗ୍ରହଣ କରି ମାତ୍ର 118 ଟଙ୍କା ଜଣେ ମାତ୍ର ଦ୍ୱିତୀୟ ଗ୍ରେଡ୍ ଶିଶୁ ପିଛା ଖର୍ଚ୍ଚ କରି ବଳକା 1151 ଟଙ୍କା ଆପଣଙ୍କ ପାଖରେ ରଖିଛନ୍ତି। ଗ୍ରାମରେ ଅନ୍ୟାନ୍ୟ ପୁଷ୍ଟିହୀନ ଶିଶୁ ଚିକିତ୍ସାରୁ ବଞ୍ଚିତ ହେଉଛନ୍ତି। 5/1/2098 ତାରିଖରେ ଆପଣଙ୍କର ସ୍ୱାକ୍ଷର ଥାଇ 11 ଗୋଟି ରେଜିଷ୍ଟର କାର୍ଯ୍ୟରୁ ଗ୍ରହଣ କରିଥିବାର ପ୍ରମାଣ ଥାଇ ସୁଦ୍ଧା ସେଥିମଧ୍ୟରୁ 2 ଖଣ୍ଡ ରେଜିଷ୍ଟର ଯଥା ସର୍ଭେ ରେଜିଷ୍ଟର ଗର୍ଭବତୀ ଓ ପ୍ରସୂତି ପଞ୍ଜୀକରଣ ଖାତା ଆପଣଙ୍କୁ କାର୍ଯ୍ୟାଳୟରୁ ଦିଆଯାଇ ନଥିବାରୁ
So there are as I find there are several allegations which he has replied. These have not been inquired into. Is there an inquiry?
No.
What is your counter? There are allegations. She has denied.
Detailed report of inquiry is of course not before your lordship at present.
You have given a copy of inquiry report annexure B/4. What is that?
B/4 I have also alleged that B/4
You can take allegation. You can proceed against a person for misconduct. But only after giving opportunity of hearing. If there is any inquiry, if any inquiry has been sir, just a moment. If any inquiry has been conducted, then she should have been
Definitely.
Given an opportunity to participate. Behind her back, you conduct an inquiry and prove the allegations. How? Whether any inquiry has been what is your counter, sir?
Counter paragraph 5 and 7, 5 and 6.
That long period of service does not confer negligence. 5 and 6.
Sir.
For which inquiry was conducted by this deponent on 15/2/2008. Just satisfy the court that this petitioner was a part of that inquiry. If you hold any conduct the inquiry behind her back and then punish her, how is it? How does it meet the requirement of audio alteram partem?
That inquiry, the proceeding.
It was impressed upon the villagers to form a food committee for the better, but the villagers did not agree and wanted ouster of the petitioner worker and they did not sign the proceeding. How then villagers filed another allegation petition against one with subsequent. So there may be some allegations.
Yes, ma'am.
They may be true also, but it has to be proved in accordance with law.
That is no doubt there.
So only says
Let me get the file in which that inquiry was conducted.
Yes, that is exactly what I want you to do. Because you see, she was called upon to explain her conduct. She submitted her explanation, which is not satisfactory. So she was again served a final notice to show cause. Again, she submitted. So then thereafter, so inquiry must have been
been personally hard.
May not be like as provided under CCA rules, CCS rules, but some sort of
natural justice. Yes.
Opportunity of hearing should have been granted.
Let me get the file.
Get the file.
B/4 ରେ ମଧ୍ୟ ସେ ମାନିଛନ୍ତି।
Again, sub collector Paloda, opposite part number 3, called field inquiry in petitioner's village along with this deponent and sub-divisional. How? If you conduct a field inquiry again behind her back. No. Anyway, third and part, learned AGA, Nesri Air Das learned AGA shall produce the joint inquiry file. The file of the joint inquiry conducted against conducted to inquire into the allegations received against the petitioners. List this matter on what a week, the week for it.
Sir, 10 September.
On 10th September.
Sir.
All right.
Interim.
Is there any interim order?
Interim.
Interim order to what?
Sorry,
If we can satisfy the court that proper opportunity of hearing was given, end of the matter.
sorry, Your Lordship, item 13, I'm for the opposite party. Favor next week.
Hey, देखो. Next week.
Item 15, item 15, last time not issued notice to the opinion number 2, the council of the CGC, but it is not returned.
My lord, we are filing the vocal number today.
For opposite party number 2.
Is it true?
Your good name, sir?
PK Basantia. I am appearing for PK Ratha.
नहीं PK रथ में नाट लिखा होगी.
हाँ लिखा है. Along with
Yes, yes. He appeared.
PK Ratha along with my name.
Yes.
कनाडा लिखा हुआ PK रथ में से एंगेज करिए ना कौन अपन पूछे. Your good name, sir?
PK Basantia.
Sri PK Basantia, advocate, appears and submits that he has instructions to. Now you have already appeared.
No.
He has instructions to appear on behalf of opposite party number 2. Stop. He undertakes to file wakalatnama by Friday.
Today.
In course of the day. Hello. List this matter next week, indicating the name of Sri Basantia in the cause list.
Counter.
I counted 15 days time. Counted.
अच्छा हो पहले पर डेट करके 3rd September.
Ah, yes, it is.
3rd September. Hello. Indicating so and so. Counter affidavit be filed in the meantime.
Not 16. Sorry.
May I please, it's the case of GRS my lord, Gram Rojagar Sabak my lord.
Yes.
She has been disengaged from her service under Annexure 1 my lord on the allegation regarding misappropriation.
Focus notice was issued.
Yes.
Misappropriation, geo tagging without case record, suppression of Muslim affair as to slopers.
Before passing of this order, my lord, she has been issued notice for show cause and she has also
No.
Right.
There is another thing. Whereas she has also admitted the fault before video casing.
in his reply, my lord, that is, she submitted the reply. Basing on that reply, this order has been passed. Of the in this order, the collector said that in reply she admits, but it's not a true fact matter. I have annexed the reply under annexure.
No. She has also admitted the fault before the video casing pour.
My lord, but that is not in the reply matter. There is
No question of reply. According to the collector, you admitted your fault before the video casing.
No, madam. There is no evidence in that respect, madam. That no document. And whereas the above admission of the
So where have you taken that averment that this you should have approached the same authority, the collector, saying that this line in the order should be expunged because I have never admitted. You should have said that. How will this court know whether you admitted or not?
there is no admission at all. I have
So how will this court know? ଆମେ କେମିତି ଜାଣିବୁ ଆପଣ admit କଲେ କି ନ କଲେ collector ଯେତେବେଳେ ଲେଖିଛନ୍ତି collector being a very high functionary, why should this court presume that he has any acts to grind against you so that he'll write something falsely? Why should this court believe that? What is the law in this regard? That if something is mentioned in the order which according to you is wrongly mentioned, then you should approach that court, that authority, and say that this is wrongly mentioned. How will this court know? Admission very recently I have dismissed a case on that ground.
My lord, so in this order, he has stated that I have filed written reply. According to that reply, the petitioner admitted, not before the I have reading my lord. And after the clause 3, and whereas the said JRS was asked to show cause in reply within 3 days of receipt of the show cause, and whereas Ms. Sabita Bag, the present person, JRS received the said notice, said show cause, and submitted her written explanation through the video. Case input had his letter number 758 dated 21/4/18, and whereas she has also admitted in the fault before the video case input. It means in that reply mail. Whereas the explanation submitted by Ms. Bag is not satisfied with reference to the irregularity committed by her. My lord, in this case, there is
whereas the above admission of GRS clearly, where is that letter?
Speaks of
Where is that letter dated?
21/4/18, my lord, under
21/4/18.
under Annexure 7, my lord. Annexure 7, page
Hold on.
16, my lord.
Hold on.
I am reading, my lord. ମୁଁ କୁମାର ସବିତା ବାଗ ସେରିଗୁମା ଗ୍ରାମ ପଞ୍ଚାୟତ ଗ୍ରାମ ରୋଜଗାର ସେବିକା ଲେଖି ଜଣାଇବା କାରଣ ଏହିକି ଯେ ପ୍ରଧାନମନ୍ତ୍ରୀ ଆବାସ ଯୋଜନାରେ ଅନିୟମିତ ସମ୍ପର୍କରେ ପ୍ରଥମେ ପ୍ରଧାନମନ୍ତ୍ରୀ ଆବାସ ଯୋଜନାରେ ଗୃହ ଚୟନ କରିବା ମୋ ଦାୟିତ୍ୱ ନୁହେଁ। ଯେତେବେଳେ ଗୃହ ପଞ୍ଜୀକରଣ ଜିଓ ଟ୍ୟାଗିଂ କରାଗଲା ସେତେବେଳେ ମୁଁ ଷ୍ଟ୍ରାଇକରେ ଥିଲି। ଯେତେବେଳେ ମୁଁ ଷ୍ଟ୍ରାଇକରେ ଥିଲି ଗ୍ରାମ ପଞ୍ଚାୟତର ସରପଞ୍ଚ ଆସି କହିଲେ କି ତୁ ତ ଷ୍ଟ୍ରାଇକରେ ଅଛୁ, ମତେ ଆଉ ପିଓ କୁ ବ୍ଲକରୁ ପ୍ରେସ୍ କରୁଛନ୍ତି କି ଶୀଘ୍ର କାମ ସାରିବାକୁ। ତେଣୁ ସେ ମୋବାଇଲ ଟା ମତେ ଦେ ବୋଲି କହିବାରୁ ମୁଁ ମୋ ମୋବାଇଲ ଟା ତାଙ୍କ ହାତକୁ ଦେଇଥିଲି। ସେ କାହା ଦ୍ୱାରା ଜିଓ ଟ୍ୟାଗ କଲେ ମୁଁ ଜାଣିନି। ମୁଁ ଷ୍ଟ୍ରାଇକରେ ଫେରିଲା ପରେ ଜାଣିବାକୁ ପାଇଲି କି କେତୋଟି ହିତାଧିକାରୀଙ୍କ ନାମ ପରିବର୍ତ୍ତନ କରାଯାଇଛି। ଏହା ପରେ ମୁଁ ଗ୍ରାମ ପଞ୍ଚାୟତ ନିର୍ବାହୀ ଅଧିକାରୀଙ୍କୁ ଜଣାଇଥିଲି। ନିର୍ବାହୀ ଅଧିକାରୀ ବିଡିଓ ଙ୍କୁ ଜଣାଇଥିବେ ବୋଲି ମୁଁ ଚୁପ୍ ରହିଲି। ହିତାଧିକାରୀ ମାନେ ପ୍ରଥମ କିସ୍ତି ପାଇଲା ପରେ ଗ୍ରାମ ପଞ୍ଚାୟତ ନିର୍ବାହୀ ଅଧିକାରୀ ଏବଂ ସରପଞ୍ଚ ଦ୍ୱିତୀୟ କିସ୍ତି ଛାଡିବାକୁ ମତେ କହିଥିଲେ, କିନ୍ତୁ ମୁଁ ସେମାନଙ୍କ କଥାକୁ ମନା କରିଥିଲି। କିନ୍ତୁ ସେ ମତେ କହିଲେ କି ପ୍ରଥମ କିସ୍ତି ସମସ୍ତଙ୍କ ଜଣାତରେ ହୋଇଛି, ତତେ ଫାଉଣ୍ଡେସନ ଫଟୋ ଛାଡିବାକୁ କଣ ଅସୁବିଧା ହେଉଛି ବୋଲି ମତେ ବାଧ୍ୟ କରିବାରୁ ମୁଁ ଦ୍ୱିତୀୟ କିସ୍ତି ଫାଉଣ୍ଡେସନ ପାଇଁ ଜିଓ ଟ୍ୟାଗ କଲି। ଗ୍ରାମ ପଞ୍ଚାୟତ ହିତାଧିକାରୀଙ୍କ ନାମ ପରିବର୍ତ୍ତନ ହେବାରେ ଜାଣି ସୁଦ୍ଧା ସେ ସରପଞ୍ଚ ଭୟରେ ପାଟି ଚୁପ୍ ରହିଲେ ଏବଂ ମତେ ଚୁପ୍ ରହିବାକୁ କହିଲେ। ଯେତେବେଳେ ଗ୍ରାମ ପଞ୍ଚାୟତ ନିର୍ବାହୀ ଅଧିକାରୀ ସରପଞ୍ଚକୁ ଭୟ କରୁଛନ୍ତି, ସେତେବେଳେ ମୁଁ କେମିତି ଗୋଟିଏ ଝିଅ ପିଲା ହେଇ ଅନ୍ୟ ଆଗରେ
ମାନେ ଘଟଣା ଘଟିଥିବାର ଆଡମିସନ ହଉଛି। She has given a different explanation that it was done by that person, କଣ ତାଙ୍କ ନା ସରପଞ୍ଚ ନା କଣ?
ସରପଞ୍ଚ
ନାଇଁ ଯିଏ ମାଗିଲେ ଇଏ ପିଓ।
PO.
She has put the blame on PO. ସିଏ ମତେ ମାଗିଲେ, ମୁଁ ତାଙ୍କୁ ମୋବାଇଲ ଦେଲି, ସେ ମୋବାଇଲରେ କଲେ। This is a clear admission.
And here in this case, PO has been reinstated. PO and programs.
That's a different matter. That's a different line of argument altogether.
Right.
But this is clear admission. What then is so the collector has written rightly that you have admitted. ये घटना ହେଲା ତାପରେ ଆପଣ ତାକୁ explain କରୁଛନ୍ତି ସିଏ ମତେ କହିଲା ବୋଲି ମୁଁ କରିଦେଲି।
Here in the allegation is misapprehension, but actually the beneficiary got the money and constructed their house.
Where is that letter reinstating the PO?
I have filed a rejoinder on
Yes.
29/9/23 to the rejoinder to their counter, Annexure 10, my lord. Annexure 10. In rejoinder, I have annexed one the job chart of GRS and other document regarding the reinstate of the PO. There is no criminal case against any person regarding me.
এটা বুঝুনি। Where is that order?
Annexure 10, madam.
Annexure 10 তো order of the
OA. Tribunal, madam.
Page 11 of the rejoinder.
Rejoinder,
page 11.
madam.
Heard in the CP, the contemnants to file compliance so cause by his next date. Release the CP after next month. তারপরে
No, page 12, last para. So it is crystal clear that the collector agada is neither in the operating authority nor recipient authority in respect of the computer program like the applicant, and therefore he has no jurisdiction and authority either to place the applicant under suspension or issue so cause notice for disengagement. Hence Annexure 6 and 7 are passed.
how does it help you? This is in relation to some computer programmer.
In this case, there are three persons implicated. One computer programmer and PO and the present GRS. Both the computer programmer and PO have been reinstated under Annexure 10, my lord.
He has reinstated on the ground that the collector has no jurisdiction. And as per the comprehensive guidelines also, and the subsequent clarification issued, which I have dealt with in another recent case, that the Gram Panchayat is the competent authority.
In respect of Gram Rozgar Sevak,
Yes,
but the action taking authority is the collective.
I don't know. Have you mentioned so?
Disciplinary authority. Hmm? 1880. Hmm?
2018 comprehensive guideline will be there. I think collector is the competent.
At that point of time, collector.
Right, 2018
18.
ପୂର୍ବରୁ ଯଦି ହେଇଥିବ
No, ସେଇଭଳି.
But the OAT has held otherwise.
We
with
in the
respect
year
to
of
the other
2018.
category of persons.
Yes, लिखिले. Type 3 computer operator. All posts shall be created as state cadre posts with the director of special projects, PR and DW department as the appointing and disciplinary authority and secretary as the appellate authority. So this is as per one letter number 5746 dated 22/3/2018 issued by the director SP and special secretary to government. So this is in respect of computer operators. 344 contractual computer operators. I don't know how is he.
So with respect to them,
Rejoined.
and my lord,
In the last occasion,
because he was a holder of a civil post, that is why my lord, treating that he was a holder of the civil post, the tribunal also entertained the original application filed by but GRS the people matter, they are not a holder of the civil.
You give a reply to this?
I think it's
You give a reply to this?
To
to the rejoinder.
To the rejoinder, yes. Learned State Council is requested to respond to the amendments made in the rejoinder, and particularly in respect of the order passed by the Odisha Administrative Tribunal, erstwhile Odisha Administrative Tribunal, in OA number 1342 of 2018, a copy of which is enclosed as annexure 10. Lists this matter.
3rd September. 17th September.
On 17th September.
Okay.
I know 17.
May I please, pursuant to an advertisement dated 26/12/2016 issued by the State Project Director OPEBA, the petitioners applied for the post of Shiksha against PH category, my lord. But both the petitioners submitted their disability certificate before the
two petitioners.
My lord,
Two petitioners.
two petitioners, my lord.
So two petitioners have single writ application? You're challenging which order? Separate orders have been passed.
One order, my lord.
One order and both of them have
Yes,
been.
my lord.
Let us see.
My lord, that is order dated 7/2/2019, my lord, page 22.
Annexure 9.
Annexure 9, page 22, my lord. Lordship may come to page 23, my lord. That is para 4 and para 5. My lord, petitioner number 1 is Smriti Kona Sarkar and petitioner number 2 is Amita Behra, my lord. My lord, they have rejected in one letter, my lord. My lord, when they submitted the disability certificate, my lord, their disability was 45% and for disability certificate. My lord, lordship now come to lordship annexure 7, my lord. Appearance for physical verification of disability of 6 candidates, my lord. And my lord, my name and page 20, Smriti Kona Sarkar, my lord. It shows that nature of disability temporary and disability percentage less than 40%. But when I submit disability temporary and disability percentage less than 40%.
But when I submitted the certificate, it was more than 40%, that is 45%. Later on, it was reduced, my lord. In this regard, my lord, Lordship has delivered a judgment, my lord.
But I don't think the facts are the same. There they had been appointed. Long after their appointment, they were advocates. This is judgment. What is the fact of that case? Find out.
Yes, my lord, Lordship is correct.
Oh, you was engaged as Shiksha Sahayak, then became a junior teacher.
Yes, my lord. But your lordship kindly come to page 15, my lord. Page 15 for a moment. The last para, my lord. Last para, my lord. Headline: there is nothing in the rules or guidelines to show that extent of disability required to be eligible for any concession benefit, that is 40%, shall have to be of permanent nature. The expression used is the minimum degree of disability should be of 40% in order to be eligible for any concession benefit. From this, the intention of the legislature executive authority is very clear, and in acknowledgement of the scientific fact that in case of temporary disability, the extent of disability may change in future, my lord. Thus, it is the extent of disability at time of engagement which is relevant.
No, because there was a lapse of time in this case.
Yes, my lord.
But in your case, there is no lapse of time.
Yes, my lapse of time, because my advertisement was issued in the 2017, my lord. 2017. Thereafter, I was given appointment in 2018. Thereafter, after 2018, my lord, I was again asked to go for a
less than 40% টা temporary হিতলে হবে নাহি বলি সেটা কোটি আছে
Government guidelines.
কাই
But there is a specific guideline to that. It must be permanent in nature and more than 40% in order to avail them.
কাই সেটা
And thereafter, another stipulation is also there. Even if a person has applied with certain certificate, but before allowing him to join or at the time of joining, even each certificate, even if it is permanent in nature, but it is to be referred to a medical board, and after re-verification, then only appointment orders.
কাই সেটা কাই
Guidelines have been annexed as Annexer A/4 to the counter. That
কোতে নাহি এটা
Next week,
এইটা আছে 8.2
ये जो conditions are stipulated personally, that is on the basis of the department guideline, because we used to refer the same mallet at the time of issuing the advertisement in the Orissa Staff Selection Commission. ଆମେ ସେଥିରେ ଆଡଭର୍ଟାଇଜମେଣ୍ଟରେ ହିଁ କଣ୍ଡିସନଟା ଷ୍ଟିପୁଲେଟ୍ କରୁ ଆଉ ଜିଏ ଡିପାର୍ଟମେଣ୍ଟର ରେଫରେନ୍ସଟା ବି କରୁ ସେଟା
ଲେଖିଲେ in case of PH candidates, provisions contained in the Persons with Disabilities Act and GA department instructions thereof shall be followed.
Yes.
So we have referred to in my previous judgment rule 3, 4 and 5 of the PWDP Act. PW
rule, Odisha rule mallet of 2003, which was governed under that PWD Act 1995. But by the time mallet, now it is PWD Act 2016 is now in operation.
Maybe that was in the judgment which I have referred.
But relating to that recruitment held in those days.
2011.
2016 days.
2011.
Sir.
ସେଥିରେ rule 3 କହିଲେ application for issue of disability certificate, then issue of disability certificate, then Review of decision regarding issue of or refusal, bola. किसे जो लिख रहे हैं देखो the minimum degree of disability should be 40% in order to be eligible for any concession benefits. That I have interpreted that it says minimum 40% disability. It does not say whether permanent or temporary.
But later on, my lord, it has been because you have, if your lordship will come to pen number 9 of your lordship's judgment, just not after. That was with respect to PWD Act 1995, my lord. Italic, my lord. Italic portion it has been quoted.
Page 9.
Page 9. Say PWD section 2T, chapter 1, preliminary PWD Act.
Page 9 to paragraph.
The following conclusions were thus drawn. Say it your italic percentage or last 2 lines. So that referring to the PWD Act of 1995. But the present recruitment matter, that is not in terms of that recruitment. So this matter will be taken up next week, my lord. I will produce those guidelines.
Only so one document.
So the SSCPD department had referred a matter when I was law secretary for opinion. In that, referring to the relevant rules, we had said that you cannot differentiate between permanent disability and temporary disability. But when the Act says only disability, 40% ठीक ଅଛି.
Like Botan said that now that must have to be a permanent.
Subsequently.
Yes.
Lordship filed a rejoinder. Lordship may come to page 6, annex 11 of that rejoinder, my lord. Well, of the petitioner number 1, my lord, that is Mukti Kona Sarkar, my lord. Actually, she is, my lord, permanently disabled, my lord.
The problem is, in all these cases that I have dealt with,
yes, my lord.
Several cases in the previous assignment, I passed quite a lot of judgments relating to this medical physical disability certificate subsequently being overturned, and I have dealt with these matters. In all those cases, there was a gap. The authorities accepted the disability certificate. 4 years, 5 years, 6 years later, they sent it to appellate medical. That is where this court has interfered. But here, what has happened is the same. They
have issued the appointment letter, but they have not allowed me to join, my lord.
That is the position, my lord. They will be offered with the appointment letters, but before joining, as it is indicated in that my lord, the clause number 8, my lord, just now it has been referred. State medical board, my lord, they have to be re-scrutinized the same, and thereafter, my lord, they can.
Well, here, my lord, state medical board has given, my lord, I am permanently disabled. I have annexed that in annex 11, my lord. So far as petitioner number 2 is concerned, my lord, I have no case. But petitioner number 1 is concerned, my lord, who is permanently disabled.
No, not document. Look at it, annex 11. This is by the government of India.
This that is a prescribed format, my lord. Annex 11, my lord. This is permanent disability certificate, and this is of 21st December 2022. The certificate and the documents which are referred to at the time of taking decision, this is the document, my lord, which has been issued on 21st December.
I know, 2022. Original, this confirms the original certificate, which was issued in 2018, 40% disability. Majiri upon the appellate medical board ko pathagala, there it was reduced to 20%.
Well, the medical certificates which have been issued, for my knowledge, my lord, with respect to that notification, that these are to be relied upon. But before issuing the engagement, the appellate medical board certificate is to be accepted.
Yes. There's no dispute about
that. There
that.
is a discrepancy, my lord. Then in that case,
yeah,
may be referred to the medical appellate medical board, my lord.
Yes, that is exactly what I'm saying.
Yes.
I'll refer it to the medical.
So petitioner number 1 is concerned, my lord. She's ready to face my lord another
Petitioner number 2.
petitioner number 2, my lord. I don't think my lord she has a case.
So should I dispose of today
As your lordship.
or should I keep it pending?
By keeping it pending, my lord, the matter.
We will direct both of them to appear. Jaha.
Yes, my lord.
Before the medical.
But in so far as petition number 2 is concerned, there is no further certificate.
Lordship, I will take instruction, my lord. Let it come next week, my
All
lord.
right. Sri Swami Learned Counsel for the petitioner. What is your full name?
Oh, 6 months.
Koushik Swami. The Koushik Swami Learned Counsel appearing for the petitioner submits draws attention of this court to the document enclosed as Annexure 11, wherein the medical certificate, the disability certificate issued in favor of the petitioner shows the percentage of disability at 40%, which confirms the original disability certificate produced by the petitioner along with her application form at the time of in 2018. Stop. Learned Sri Swami requests for some time to obtain instructions as to if petitioner number 2
Yes, my lord.
has any such certificate. Is this matter next week? Or
Yes, my lord.
next week. Oh. कर देते हैं 3rd September.
Yes. Oh, yes, my lord.
Item number 18.
I am from Matrimonial. Counter,
Yes.
they have to give the counter. But they have not served the counter copy to me, Milord. Let them serve the counter copy so that I will file the rejoinder and this matter will be disposed of.
Let pleadings be exchanged between the parties. Let this matter in the week commencing.
9th September, 10th September.
10th September. Yes.
Item 9.
In the meantime, they may be directed to serve the
Yes,
counter copy, Milord.
Yeah, qualified.
Tomorrow it will.
I've said already passed that order. Yes.
Okay.
Item 19.
Miller. Did you hear the petitioner?
Postal tracking report shows that notice on opposite party number 5 has been delivered. There is, however, no appearance. Yes.
Let you hear the petitioner Miller, though Sport Miller passed in the selection, but she was not given engagement. Rather, the opposite party number 5 Miller, who was scored the less mark, has been given engagement on the ground that this petitioner has not uploaded the caste certificate. But in fact, Miller, that caste certificate was uploaded. They have considered the sum and also awarded the mark for the sums. And now they are in the counter. They have stated that we are wrong.
No, what happened? What happened before we go to the counter? What happened? Why did you come to this court?
But, because Miller, that was uploaded all the certificate, considered, and they have awarded the mark. But now, Miller, they have stating.
No, were you selected?
No, Miller, they have not selected me.
So that is what I'm asking.
That is Miller.
What is your name?
Miller, the Kosturi Kausalya.
लिखा है caste certificate not uploaded.
Caste certificate uploaded.
इसी लिखी जाए
But I have uploaded in your lordship may see that annexure 2 Miller page 10. That application I have uploaded that. Attachment, attached document Miller. The residence proof attached.
You challenge it in appeal.
Miller, I have
File appeal.
Miller, your lordship.
Yes, it's an appealable order.
Yes.
এটা পুরনো answer হবে বোধহয়. This is 2000.
Yes.
ADM.
This is 2022. Then it will lie, only one appeal will lie before the ADM. The petitioner was an applicant for Anganwadi worker of the कौन जगह?
Chichinga Anganwadi Center.
कौन?
Chichangobari.
Chichangobori Anganwadi Center mini. Chichangobori mini Anganwadi Center. Pursuant to advertisement issued on 21/6/2022. She claims to have submitted all relevant documents along with her online application, including copy of her caste certificate. The selection committee, however, wrongly mentioned that caste certificate was not uploaded, even though caste pay mark caste pay to mark no, even though she was awarded 10 points for being SC na ST? SC candidate. As per the comparative statement for selection prepared on 21/9/2022. As such, despite having secured the highest marks among all the candidates, the petitioner was not selected. Stop. A counter affidavit has been filed by the state justifying the non-consideration of the petitioner's candidature. So, be that as it may, this court finds that the order of engagement, the selection of opposite party number 5 as Anganwadi worker can be challenged by the petitioner by filing appeal before the ADM as per the revised guidelines dated 2/5/2007. Since alternative efficacious remedy is available, the writ application is disposed of, granting liberty to the petitioner to prefer appeal before the ADM within 2 weeks from today. Okay?
Yes, my lord. You'll not target the same.
Room. Apply delay kono na bonege. Delay file kichu hoboni. 2022 ro case ebe jibe jetelo icha apna appeal ta file kar debe apna. Jende hobo dile. Na delay kono darkar nei je mu chhad dutta.
That in conformity with the remedy is available, the certificate from the report until the certification of for an update before the reviews within 2 weeks from today.
2 weeks from today. Such appeal shall be filed along with an application seeking condonation of delay, which shall be considered favorably since the petitioner, rightly or wrongly, had approached this court in the present writ application by filing the same on 10/10/2022, that is within the period of limitation. Sir, 29 नौ रही थी ना कहते इतना engagement है 26 नौ रही थी हाँ तब ठीक है within the period of limitation. Further, the appeal shall be heard and disposed of in accordance with law after granting an opportunity of hearing to the petitioner as well as the selected candidate and other necessary parties within 2 months thereafter. Yes.
Item 20.
What is this, Mr. Mahapatra?
My lord, I have challenged that appellate order, your lordship will find at page 49, annexure 11.
Anganwadi?
Anganwadi.
Annexure?
11, your lordship.
Annexure 11, yes.
The advertisement was challenged by OP number 7, who belongs to SC category. That advertisement was quashed. Even no, I have not been made a party therein. And other candidates have also not been made party therein. And advertisement is not a part of the selection.
Let us see 2/5/2007. Whether the 2/5/2007 का होता था?
No, appeal, my lord, the advertisement is not a part of selection. So whenever selection is concerned, it is appellate.
That is what I am saying.
Just, my lord, I want to bring the facts before lordship.
Mr. Das, this involves interpretation of clause I under the heading procedure. of 25/2007.
Unfortunately, we have missed that book today.
ନା ମୁଁ ଦେଇଦେବି ଲେଖା ହେଲା ADM will be the appellate authority for hearing complaints regarding selection of Anganwadi workers for tribal and rural projects and urban projects. So complaints regarding selection of Anganwadi workers here, whether the ADM has the power to
Quash the advertisement.
advertise. That is the sole issue to be decided in this case. What is your counter? Is this?
I have filed counter. The advertisement under challenge under rank 11.
You are the.
No. I am the SC candidate. Though advertisement are issued, inviting application from only ST candidates. I belong to SC. When in other Anganwadi center, sub-collector and I invited applications from both the parties, SC and ST. For that, I challenge that. I came before the
we are on a larger issue. Whether you could have filed a representation, that representation could have been considered. But whether the ADM has the power to quash an advertisement.
I came before this honorable court. I came before this honorable court challenging advertisement. This honorable court granted liberty to file appeal. Before,
where is that order?
That is, my lord, WPC. That is in 8807, my lord. In 8807, my WPC 25729 of 21, in which order was passed. And I have filed one IA in 8807, second case, my lord. In that item 20.
In fact, there is no order by there. That is also pending. That has come before us.
And I have filed one IA.
That might be what you said, that the direction is given to file up.
Yes.
That's an order.
No. In that IA, I have enclosed the documents. Page 6, one IA in 8807, IA number 15463.
I will take a different view.
Liberty is granted to me. Thereafter, I filed
maybe.
Appeal before ADM.
No.
My lord, the order on the challenge, that must be a certified copy. What at Annex 11 is a certified?
No. Let me tell you one. The earlier writ application, you are Sujata Digal.
My lord.
You had actually, she had filed a earlier writ application.
Yes.
Seeking to quash the advertisement dated 36/2020 issued by the CTPO.
Under Annex 1 of the question.
Now, the Additional Standing Counsel raised a preliminary question with regard to maintainability of the and says that against the selection and engagement of Anganwadi worker, appeal lies. And instead of preferring appeal, the petitioner approaches this court.
Yes.
In view of the above, the court is not inclined to entertain this application. Liberty is granted to approach the appropriate forum ventilating.
Yes.
But I think this question is still open.
Yes.
Even though she was granted liberty by this court and she filed an appeal.
I had to file appeal for ADM.
No, that's all right. Since you were permitted by this court, you were granted liberty, so you could file an appeal. But it all depends on the interpretation of that clause.
What held by the ADM, though that advertisement was issued,
instead of
without following the procedure,
with great respect to the coordinate bench, actually liberty should have been granted to you to prefer simply a representation before the collector or the ADM, whoever is the appropriate authority. In the administrative side, he or she could have passed some observations.
Cannot be also an appellant. For the reason your lordship may kindly come to the facts. Your lordship may kindly see the advertisement.
No, it is clear. It is clear our fact.
It will be clear manner if your lordship will see the advertisement. Your lordship may kindly see. Okay. Your lordship may kindly see.
Point of law.
Your lordship may kindly see page 70 of the advertisement starts from page 16.
Of the counter.
You lordship may kindly see 5 Anganwadi centers. For 5 Anganwadi centers, advertisement was published. He is for 1 Anganwadi center. Now the total 5, the total advertisement is cost.
Though no procedure.
3 persons have been given appointment, state is remaining silent. I have filed 2 repeated applications, 2 persons have been selected therein, and they have submitted their joining report. They have not been allowed to join, and subsequently writ application was filed before this honorable court. Notice was issued to all these state functionaries who are the necessary parties. They are aware of the fact that writ application is pending, but picking this lady filed the appeal for the advertisement. And up to 5 Anganwadi centers. Can it be? She is concerned with 1 Anganwadi center. But now 5 Anganwadi centers.
Yes, sir. What would be your reply?
In fact, each of the writ petitions, there have been counter affidavits
Yes.
saying that the,
Let us hear and dispose of this matter finally.
yes,
Get ready on any day, you say, or today also I am ready.
No, Lordship, I will file it in notes.
Written note ପାଇଁ ଆପଣ argument ସରିଲା ପରେ written note file କରିବେ.
16th.
No, this is the only question.
Yes.
First is whether, so this court had, rightly or wrongly, this court had passed an order granting our liberty to appeal. But subsequently, again, a coordinate bench finds that such an order could not have been passed because there is no provision for appeal to challenge the advertisement. Selection can be challenged. Selection process can be challenged. But the advertisement itself, I don't think the ADM has the power. This is my view. Prima facie, I may be wrong.
Yes.
My lord, he is the
And
applicant.
secondly,
Yes.
as he has rightly pointed out, the appellant is concerned, can only be concerned with only one advertisement, only one Anganwadi
But
center.
she has applied,
Where
yes.
she has applied. She cannot, at her behest, the entire advertisement could not have been quashed. It would have been confined only to that particular Anganwadi
That center, yes.
isn't it?
And another,
Thirdly, how could the state council make such a submission?
Oh, good.
See, Purna here in the previous application, it is the state council who says that it is not maintainable and appeal lies against this election. That has been interpreted as
Under
a,
misconception that statement has been made.
no, you have to come up with a specific stand whether an appeal actually lies or not. This is a question of law again.
and fourth point is, your lordship, she is not the applicant in respect of to that advertisement. She is not the applicant.
Then
She has not submitted any application.
so at the instance of a stranger or an outsider, how can it be done?
Right.
The entire.
How could the appeal be entertained?
Well, I have challenged the advertisement. Though in other Anganwadi sector, both AC and ST, they were allowed.
Without being an applicant, how could you maintain an appeal?
For that, I challenge my lord, ଯେହେତୁ ଆମକୁ ଦଉନାହାନ୍ତି ସୁଯୋଗ, ସବ୍ କଲେକ୍ଟର ଫୁଲବାଣୀ ସବୁଥିରେ ଅଛନ୍ତି ତାଙ୍କ
You had rightly approached this court. She had
Some
rightly
Anganwadi
approached
center
this court.
SC,
Did not entertain it is a different matter, but she had rightly approached this court.
Yes.
Saying
It
that
is a
the,
question of disputed.
saying that the ST candidates only ST candidates are being
yes,
called.
yes.
So I think
ଯେତେବେଳେ କି ସେ ଗାଁରେ ST ନାହାନ୍ତି.
And on the ground which is,
As she
it
was
is
an
passed,
outsider.
that notification doesn't exist. Subsequently, it is revised. On the basis of which notification it is passed, that notification doesn't exist.
All
Like
right,
that.
then let us take it up for final hearing.
Well,
When?
Next week, anything.
Pattern of. Please, August. All right, third in part, list this matter on 28th August.
okay.
Parties are requested to come ready for hearing on final disposal. Item number 22. 21 to come. Please.
My lord, I am submitting before the Sun Court to challenging the notification. I am the Anganwadi workers, my lord. It is working in the block of Asika and Sorda block in the district of Ganjam, my lord. And coming to the challenging the notification issued by the Orissa Subordinate Staff Selection Commission and dated 29/12/2023, which is for appointment of Anganwadi supervisors. So ignoring this, candidates of the working Anganwadi workers on the said district. So, and right annexure 1, my lord, kindly see page 12, my lord, page 12 to ICDS supervisor for females only. My lord, in this case, this honorable court also, previously they are coming to this honorable court to challenging the promotion, which this honorable court has passed the order and dated 2/3/2023. Still yet it is pending. They are not taking, the collector Ganjam has not taken decision.
No. What is the grievance? You have referred to annexure 1.
Annexure 1.
Advertisement. So
Yes.
advertisement was issued.
Yes.
Then what happened?
Only that without considering the 40% of the Gazette notification as per page 67, my lord. Page 67, there is the Gazette notification of the past issued by the state government. It's on para 4, my lord. Number 4, and the 30% is the reservation. That reserved for the post of the recruitment accordance with the rule 7 to extent of the 30% of the total numbers of posts in cadres.
So 30% will be promoted from Anganwadi workers.
Yes.
Yeah, though?
Yes.
Yes.
And also, my lord, committee, and that's this honorable court's order, my lord, can you see clear that it's also page.
I've seen it.
Yes.
Just a moment. Yes. Mr. Patnaik.
May be permitted to place the prayer.
The prayer panel amendment, I have filed it previously the honorable court has given, I have amendment.
So, my lord, that is what my lord I am submitting. Previously, there was a prayer, my lord. And in the meantime, IA number 6722 of 2024, an amendment petition has been filed. A copy has been sought upon me, wherein, my lord, he has made a prayer to amend the prayer portion.
Where is that IA? IA number?
6722 of 2024, my lord.
No.
That is for the prayer for amendment, and today also the list also, my lord, is not indicated.
Not indicated.
So, my lord, that's not until that prayer portion will be amended. Because we don't want to phrase
List this matter tomorrow along with IA number.
That is 6722 of 2024.
37.
6722
of 2024.
2020.
Tomorrow it will come.
Yes.
16th. 16th.
All right, on 16th.
Okay. Item 23.
No, T says it will last.
Postal tracking report.
That's why I'm number 9.
Postal tracking report. Exponent of 9 has appeared. Yes.
And in this case, my lord, on 9/7/2024, my lord, notices were issued.
Yes.
That they had to receive the power wise government. One more opportunity.
National Health Mission.
I am appealing for the opposite party number 2.
Yes, Mr.
The formal party, my lord. Opposite party number 7's action is under challenge. My lord and friend will file an affidavit counters.
How is you are the private opposite party?
My lord.
What is your stand in this case?
I am the secretary candidate, my lord.
You are the secretary. You want to file counter?
No, yes, my lord.
So date will
All right. The opposite party number 9 has entered appearance through your good name, sir.
Subhasis Satpathy.
Sri Subhasis Satpathy. You filed your wakalat now?
Well.
Subhasis Satpathy, who requests for some time to file the counter. State Council also requests likewise. List this matter. 10th September. Counter affidavit will be filed in the meantime.
Yes.
Item 24.
Mr. Chan, on behalf of Suniti Patnaik, adjourn for next week.
Item 24. On behalf of?
Suniti Patnaik.
Who is she?
I am associate, Mr. Chan.
No. Which list are you referring to? Which is the case? Who case time maguchanti?
T4 case.
Case kain brief kain apan ko case ra apan maguchanti kounanti? There is no Suniti Patnaik. The petitioner's counsel is Arupananda Das, R.R. Mishra, M. Chand. So who is Suniti Patnaik? That is what I am asking you. Apan ko case ra kounchandi? Case ra
It's not there.
Again?
Mr. Chan is not there because due to
ठीक है. But you are saying Miss Suniti Patnaik. There is no Suniti Patnaik here. Arupananda Das, R.R. Mishra, M. Chand. Yes. Court को अक्षंती है हाथ ब्रीफ टा धरिबेनी को मैटर रे कहउचंती ताको आपण कोर्ट पछाले कहबेनी. What is the case number? Who is the petitioner? All right. As requested, list this matter. When do you want?
next.
All right, next week.
25.
That's all.
26.
That's all.
Item 28.
No instruction.
No instruction dispose of.
Obliged.
Item 29.
Please, your lordship. That's item 29. Here,
You have to take fresh notice, Mr. Satkati.
press notice.
No. You are directed to intimate the present status of the case in the
Yes,
court.
your lordship, the matrimonial civil suit is pending.
Pending.
Yes, your lordship.
All right. Sri Satkati, learned counsel for the petitioner submits on instructions that the case in the court below is still pending. Since notice has not yet been served, let fresh steps be taken for service of notice on the opposite party by registered post, fixing a short returnable date. The requisites be filed within 3 working days. Let this matter.
7 days.
Is this matter on
24th September.
24th September, interim order to control.
Item 31,
Pass over.
item 32,
32, I am for the opposite party. Here, my lord, the petitioner.
The petitioner तो ना थे कौन करे?
Lord, here, in fact, already expert judgment has been passed. He took twice time in order to get it set aside. But till late, my lord.
Let us pass it over. If it doesn't appear, then we will see. As in all, the 2023 matter. Yes. Item 33.
After launch.
Mr. Mathi is there. Yes.
Your lordship, this is a
32.
Yes.
Come for the petitioner lordship. Lordship, in this case, lordship.
Mr. Harichandan says that the case has been disposed of.
CM already been filed, lordship, and today has appeared before the date was fixed before the court below. And court below, he has the opposite party has appeared today and filed a time petition for hearing this matter. And the lordship, in this case, lordship, so very cunningly, the opposite party has, while matter stood pending before this honorable court, and notice has been issued, and you have duly received the notice, and the petition is a lady and having small child and residing at Raulkela, and it is very difficult it is very unfortunate to appear before the Puri court. It is a jurisdiction because there is a large.
So they kebe roila case ta tala court CM ta
tala court aaj some time petition ebe deychundi.
Tala court aji thila.
Time petition se appeal ke time petition deychundi. So date ta to heini date ta but 1 month rahu either.
Prior to this also, section 9 application was filed. Notice was issued. They did not appear in that case also. Expiry order was
the petitioner submits that CMA number 205 of 2024 was posted today before the court below, and the opposite party has appeared and sought time to file his replies. The next date has not yet been fixed. List this matter
17th September.
on 17th September. Is there any interim? No, interim order of one.
I think 33.
33, yes.
33.
Your lordship, this is a case of transfer petition from SDGM Raulkela to Bhubaneswar.
Yes.
On the last occasion, your lordship had directed to file requisites with correct address to the opposite party.
Postal tracking report reveals that notice on the opposite party has been duly served. There is, however, no appearance.
Yes, your lordship.
It was served, Kodana.
Your lordship.
All right, we'll grant one more opportunity in order to grant one more opportunity to the opposite party to appear. List this matter on
3rd September.
3rd September.
Your lordship may kindly grant a stay on the proceedings of the.
Is there any interim order already passed?
Yes, sir. On your first order, lordship, on IA number 32.
All right, interim order to adjournment mein rahi.
Yes, sir, your lordship.
Stay kar do.
Grateful, lordship.
35, my lord, the petitioner is the wife, my lord, pressed for a transfer of the transfer is CP, my lord, from Lawrence Judge Family Court, Kotak to the Family Court, Fulbani.
You are appearing.
May I please, your lordship?
You are appearing.
Yes,
wait. Any chance of settlement?
My lord, yes, there is chance of settlement, but in the instant case, the opposite party petitioner has not made the paramour as a party in this transfer petition. Though the petitioner received the notice in the matrimonial case in the house of the paramour. ଆମେ ଲେଖିଥିଲୁ ପାରାମର ଘରେ ରହୁଛୁ ପାରାମର ଘରେ ହିଁ ସେ ନୋଟିସ ରିସିଭ କରୁଛନ୍ତି
ସେଟଲମେଣ୍ଟ କଣ ହବ
ଭୁବନେଶ୍ୱରରେ so the defect in the present petition is that they have not made a party the paramour in the transfer petition.
Defect has been pointed out.
He is not a contesting party.
No, that but you have not mentioned his
Transport petition, my lord.
so param he is a interested party in this case.
He is a perform opposite party. He is not this is a
Milord,
this is not a hearing of the transfer for civil proceeding.
as per the Odisha High Court rule, all paramour should made a party and he cannot be a perform opposite party in this case.
Whether the matter can be settled?
Let it be referred to the medicine center.
Mediation center at Pulvani.
No, Milord. She is staying at Bhubaneswar only.
Not
Because she belongs
parents'
to
house.
no Milord. Because she belongs to a community.
He is the relative of the
Her
authority.
mother is threatening me to put in danger, particularly in CSTPA Act.
Then
if I go there.
They have bear
But she is staying. She received notice in Bhubaneswar only.
We will do it at Cuttack High Court Mediation Center.
Milord.
They have to bear the cost.
Yes, yes. You bear the
Milord,
cost.
I am an auto rickshaw driver.
बस भड़ा देबे
भड़ा देबे मैडम
ऑटो रिक्शा ड्राइवर को कम रोजगार ना
फुलबाणी टू कटक मलन
भड़ा देबे
से एकोटे आसीबन जोन संगरे आसीबो
जरा आसीबो जरा अटेंडेंट कर भी पैसा देबे
आ से आसीबो जिबा आसीबो होटल रे खाइबो
ना ना होटल खाइबा पीबा बुलिबे फिल्म देखिए
फिल्म खर्च ना रहिबो तो फूड कोर्ट
ना दिस जोर रहबो सेत्र ही परिबो एत कथा
Milord, my humble submission.
She is
staying at Bhubaneswar only.
Sir,
Let me
आपण जानो कि ठीक है आपण यू आर बिकमिंग टू इंटरेस्टेड
Milord, the paramour होची opposite party number 2 in the court below.
you have already made that submission
Milord. So she
why are you repeating it
Fulban ru asi kojonto because she will have to come from Bhubaneswar only, Milord. That is the case.
This court will not enter into the controversy whether she is at Bhubaneswar or at Fulbani. So who will how will this court know when somebody says that she is at Bhubaneswar, somebody says that she is at Fulbani? How? So you bear the expenses.
Milord, I will bear the actual expenses, Milord, of transportation.
हाँ बस भड़ा देबे
Milord.
दियों को बस भड़ा देबे
Milord,
दियों को देबे नले आपण काम करदो आपण फुलबाणी डीएलएस सेंटर को जाओ
it will very
No.
there is a threat to I will
no there will be no threat
Milord, Milord, kindly pardon, Milord, this otherwise
no
Milord, High Court Mediation Center ro Milord
No.
expenses
No.
bear kari.
No.
Milord, otherwise this I will be highly prejudiced because I am strongly contending not to go Fulbani, not to transfer the case. Otherwise I will have to go Fulbani, Milord.
So
No, this I will be highly prejudiced, Milord. 8 High Court Mediation Center ho Milord. Let there be a try by the
no
trained
no
mediator.
no
Milord,
no I will hear the main application on merit. Aram karo
Milord.
Aram karo first satisfy the court that your application is in order when you have not made the paramour as a party. You may now do it if you want because she is a party in the court below.
Permit me, my lord, then I will make the
Why should I permit you? It is up to your case. I may grant you 7 days time. If you don't do it, then your case will go. Then I will consider your merit.
My lord, grant 7 days time, my lord.
Yes. This matter next week.
Consider
As learned counsel for the petitioner wants to amend his application. Yes. Yes. Interim order to cut.
Deep privilege.
Item 35.
Return answer, my lord.
But I am on VCM my associate.
You are appearing on behalf of the opposite party.
But that's my
What is your name, sir?
Satya Prakash Satpathy. My associate is there before you, your lordship. He will be filed.
Yes,
The power on web.
Yes, Satpathy has entered appearance on behalf of the opposite party by filing Vakalaknama in the court. The same be accepted. His name be reflected in the cause title. Yes, is there any chance of settlement?
Your lordship, the previously a similar TRPC has already been disposed of by this honorable court.
in TRP 76 of 2073 of 2023 by order.
All right, let's just meet next week along with the TRPC number
73 of 23.
73 of 2023. Yes, next week.
Your Lordship, a copy may be sir.
Ashe asu dekhiya.
Item 36.
36 wala notice was issued. The thing is there that
Anybody appearing in this matter for the opposite party? Notice was returned saying address can't be located, not known to the local people. Whatever address you have given.
address as per the MAT case, I have
Hmm.
MAT case was filed by the husband. Husband has given the address.
At
Whatever
present,
address he has given.
Ashok Nagar, Athagad PS.
Okay.
So then there's another Jilinda post Jodum. There are two addresses.
Two addresses. So, Lordship may kindly allow me to take notice on both these addresses again.
All right. Issue notice. Issue fresh notice on opposite party. In both the addresses. By registered post. Learned counsel for the petitioner shall file two sets of requisites for each of the addresses, for both the addresses. Short returnable date be fixed. Yeah. Requisites be filed within a week. This matter. 24th September, I arrest take the
Interim order is
the graphical error in the transfer application in court.
Item 38.
Here there are three matters before your lordship. Filed by the same parties and parties are same. In TRPC 142 of 2024, my lord, I have already filed requisites. It is noted in the notice has to go in that matter. There is an interim order in my favor. The lordship may accept that requisites and issue.
What about the others?
Yes, I'm coming, my lord. This is the first one. In TRPCRL, my lord, there are two TRPCs, first item and last item. Both the matters may be tagged together. TRPCRL is also assigned to your lordship, but there is an application for modification that is IA number 45 of 24. It has to go before Justice BP Sarpati because I am seeking modification of the order passed by Honorable Justice Sarpati.
Okay. Requisites filed be accepted and notice be issued, fixing a short returnable date. Let's this matter.
24th September.
24th September, interim order to continue.
Well, in TRPC number 120 of 24, your lordship may issue notice on it. Parties are same.
This is against another.
Another person.
All right, issue notice. The opposite party by speed post. Fixing a short returnable date, requisites be filed within 3 working days. Let's this matter on.
24th September.
24th September.
Along with the other TRPC.
Along with TRPC 142 of 2024. है ना? TRPCRL 48 of 2024 Since the petitioner seeks modification of order dated 28/5/2024 passed by the coordinate bench, registry is directed to list this matter before the said bench with kind permission of Honorable the Chief Justice.
Item 39.
No, my lord, the petitioner is the wife seeking a direction to transfer the MAT case number. MAT case.
Who's the opposite party? Somebody has appeared?
Yesterday this matter was there.
He appeared kali?
Na, kali thila. Gato thila.
Gato thila? Who to transfer?
The
Bank for that.
bank.
CS for Learned counsel for the petitioner is present. None appears for the opposite party. Yesterday also there was no appearance from the side of the opposite party when the matter was called out. Hello. The transfer application is therefore taken up for hearing. Allow kar
Item 40. May I plead your worship? In this case, I am for the petitioner wife. The opposite party has filed a petition under section 9 of Hindu Marriage Act before the learning civil judge come family judge bank.
Is not appearing. Yesterday, this matter was there.
Yes, it was.
You wanted to be transferred from which court to which court?
Banki to Bhubaneswar Family Court 2.
Same order kari allow kar.
Well, one more submission. My name has been wrongly mentioned Lingaraj Das instead of Sarangi. Lingaraj Sarangi.
Lingaraj Sarangi.
Again.
The name of the counsel appearing for the petitioner be corrected as Lingaraj Sarangi.
Deeply blessed.
Item 41. May I please repeat? I am for the wife. I have filed 125 proceeding before the judge family court for that, where I have given evidence, and the evidence was of husband was there, he was not appeared, and thereafter, after 2 years, after I have filed the 125 in the year 2022. Thereafter, I have given my evidence. That evidence of husband, she is not coming. And in order to harass the petition, he has filed a section 9 petition before the judge family court of Bhubaneswar. I am with 2 children under
counsel for the petitioner is present. None appears for the opposite party. For the previous occasion also, there was no appearance. Allow kar diya.
Last time, wala taraf extension nahi. Last.
No, somebody has appeared. So his name is not there, so we'll call it tomorrow. Sri Dharmananda Subudhi, advocate and associates have entered appearance for the opposite party. Their names be reflected in the cause list. Call this matter on 16th. Yes. Yes.
Item 42. 42, I pray for last assessment.
Yes, what?
Granted and once extended.
Last lady tha husband.
Photographer.
Last chance. I will never, my lord, pray for further. Last.
Considering the submissions, the prayer for extension of interim bail is rejected.
My lord, last.
Yes.
My lord, lordship.
आप कौन remove order pass कर सकते हैं?
Item 43.
No.
Lordship.
Order excellent. Shut up. Yes. 43.
My lord, beg your pardon. It is a split up trial case, but erroneously on the cause title we have mentioned the case is pending before the second additional session judge Khurda. The accused person arrested and their case is in the trial.
All right, learned counsel for the petition is permitted to correct the typographical error relating to the name of the court, in the office. 2 weeks time darkar tho.
My prayer is to correct the name.
That I have corrected, sir. I have directed you to correct, so you will have to correct.
I shall correct.
Eat kar do.
Item 44.
No, you have wrongly mentioned in your. Sheet correction kar do. Hame to answer office ye kar do. Yes, Mr. Patnaik.
May I please, Your Lordship? Well, the case is under section 302, 201, 342, 506, 34 of the IPC, and the petitioner is in custody since 23 October 2020 manner. In between manner, one Mangu Maji in similar footing released on bail for 2 months, Your Lordship. And out of 11 witness panels, some of the witnesses have been examined, and eyewitnesses are not supporting the prosecution case.
namely eyewitness.
I've already granted you 2 months bail.
2 months
Interim
interim bail, yes.
No further.
Somnath Jala.
No,
In time he surrendered.
no.
In time he surrendered. My lord, ये भी आगरू पाई था तापर से
No. Considering the submissions, the prayer for interim bail stands rejected.
My lord, already out of 11 witness.
I have rejected it.
My
Mr. Patnaik, no. Murder करी कि ता स्त्री अगर murder करी तो को पोड़ीले जीवंता पोड़ीले.
Yes.
That still then I granted you interim bail.
My lord.
And now you want extension.
At least गोटे मास.
No, no.
Case or
गोटे घंटा भी देवी. Reject रही silent. Mr. Patnaik. कोई भी तो order देखना sanction type करिए sign करिए अपने हाथ रख कर दे देवी.
permitted to.
No, no, no. Rejected or permitted to withdraw. Rejected. No, no, not permitted. Permission not granted. No, interim bail. Yes.
Item 45.
Obligers.
Item 41 pass over.
All right. Pass over.
Item 46.
46, my lord, pass over.
All right. Pass over.
Item 47.
Pass over.
Item 48.
Yes, Mr. Jyoti.
Item 48, my lord. Today I have got a file IA seeking for integrity certificate day after Friday.
You have already filed?
I already filed.
What is that number?
Number not.
So today you have filed?
Yes, sir.
Next week also along with the IA. Let's this matter
Thank
next
you.
week along with the interlocutory application said to have been filed by the petitioner today.
Item 49.
May I please item 49 extension of time, first time extension of time.
2 weeks time.
21/5.
2 weeks time.
Obliged.
Item 50.
Maybe on behalf of Mr. Nanda, my lord, a similar putting working person has been granted bail, my lord. It's a offense on the system.
Mr. Ranjan Sahu. 354 506 379.
Visoranjan Sahu has been granted bail. Yeah, Mr. Mishra, same.
Yes, ma'am.
All right, same order. Pass over, Deco.
So item number 5.
May I please, your lord? My lord, the petitioner is applied for the post of second side, who is working as a
You want Kagoji? Yes. Jogan Sayako.
my lord. He is continuing as Jagan Sahayaka since last 10 years, my lord. Then, my lord, the opposite party published advertisement for the fresh recruitment, my lord. And in view of that,
No,
advertisement,
your prayer says that to direct the opposite party number 3 to give engagement appointment to the present petitioner as Jogara Sayaka.
pardon, my lord, my prayer is, my lord.
So since he is working in this head post in the last 10 years, so tamare regular appointment.
No. This is not a regular appointment. What
Contractual.
Contractual appointment. What happened, my lords? Since last 10 years, I am continuing as Jagan Sahayaka. Subsequently, the authority made an advertisement for the same post, my lords. I, along with other person, applied for the same post, my lord. That is still pending. And they have prepared a penal list. In penal list, my name has been found place in serial number 2. And option number 5 name has been found place in serial number 1. So far, my grievance is concerned that as I am continuing, they are not giving reference to me. And second point is that, my lord, that the opposite party number 5, who is not the resident of that locality, managed to get some documents to prove that he is under that jurisdiction.
Is there any such requirement that he has to belong to the same?
Yes, my lord. That is the, my lord, the parameter as per the advertisement. And that is why I made made him party at option number 5. Even if I have, my lord, ventilated my grievances.
So he has been appointed?
No. I am continuing there. Only they prepare the penal list under annexure, my lord, 1.
Take notice.
My lord.
Mr. Das, you can accept for 1 to 4. Learned AG accepts notice. Das Learned AG accepts notice on behalf of opposite party numbers 1 to 4. Issue notice to opposite party number 5 by registered post with ID returnable within 4 weeks. Requisites be filed within 3 working days. Let's this matter. October.
All
right. As an interim measure, it is directed that the panel list prepared on 8/11/2023 shall not be given effect to, if not already given effect to.
Yes, ma'am.
Till the next date. Voilà.
So item number 25.
None appears, disposed of,
So I don't know 26.
disposed of,
So I don't know 31.
31, 2021, no? None appears on repeated calls. List this matter next week.
So item number 45.
मतलब 45 में kindly be pass over sir.
How pass over कौन? Dithar pass over लाने को? Dithar pass over लाने को?
Well, it's one last chance maybe it may be taken up after lunch.
Next week as
Next week, yes.
yes, ma'am.
List this matter next week.
So I don't know 46.
46, next week.
So I don't know 47.
Section 302 IPC, my lord.
ठीक है, आगे order टा correction कर दो. The order dated 6/8/2024 be corrected appropriately. The EBL appeal है ना? Yes. Yes, Mr. Naik, what is this matter, sir?
It's an application for interim bail, my last time it was listed, but I had not filed an application for interim bail, my lord, for which your as per your lordship's direction, I filed an application for interim application, my lord.
What
The
is
case is under section 302 IPC, my lord, on a marriage procession, my lord. A vehicle was passing on, and there was a decoration, my lord. And while the decoration was hoisted by my lord, it was damaged by this vehicle. There was a quarrel. Thereafter, it is alleged that he attacked. One of them is dead. On merit, your lordship has rejected my applications. I am not on merit, my lord. I am in custody for 8 months. I was an old parents, my lord. Only
You are Deepak Patra.
yes, my lord. I pray, my lord, 3 months or your lordship's discretion, whatever time may be. Last time I have filed all this, my lord, but since there was no IA, I was directed to file an interim application. I filed an interim application, my lord. 8 months in custody.
Rejection order.
Yes, I've read it.
Yes.
The eyewitnesses have already,
Yes.
but they have not been examined.
No trial.
Not trial, not trial. That is one of my ground. Charge has not been framed. Hey.
IA. IA refer to IA 1012 of 2024. Yes, Mr. Mishra.
Lord, we have filed IA without any document, only for delay in trial.
Old parents will be documented. I have not taken a plea that anybody ill and arranging medical sector. That
Therefore, interim bail has been made on the ground that the petitioner is the only earning member of his family and has a female child. So further, he has his old parents, old and ailing parents to take care. He therefore, it is therefore felt that he may at least be released on interim bail for some time. No. Parents State Council opposes the prayer for interim bail on the ground that his regular bail has been rejected on merits. Well, considering the submissions and the grounds on which the prayer for interim bail has been made, I am inclined to take a lenient view. Since the petitioner is in custody since 26/9/2023. Well, let the petitioner be released on interim bail for a period of 1 month.
my lord,
1 month.
3 months, go through 2 months. Your lordship's previous sentences, I am inclined to take a lenient view, my lord. So lenient.
I have taken a lenient view, sir.
So lenient view.
Sir, I have taken a lenient view with your experience when 2 eyewitnesses have stated that you have done settled bail.
In the very beginning, I have submitted, my lord. That's I
As a court
on
file
merit,
follow.
yes. I have said I am on merit in August. 2 months, my lord. Old parents. 2 months.
6 weeks.
6 weeks. Prati week appeal karo trial and
on the condition one, he shall appear before the Kothana.
Gopmal.
He shall appear before the IIC of Gop Police Station on every Sunday at 10 a.m. and such fact shall be certified by the IIC to the concerned court every 15 days. Each day appearance in the court. Next, he shall not influence the witnesses. Sorry,
Lordship, fix a date.
list this matter. Bail application.
6 weeks means from the date of release.
Date of release?
That
No, the main bail application is kept pending. No, Mr. Naik. Mr. Naik, the main bail application is kept pending.
Yes, sir. Yes.
List the main bail application for hearing on তারপরে যখন
IA is disposal of minor.
IA is
Yes.
disposal
22nd October.
22nd October.
Well, it's item 45 that I mentioned. I apologize for that. Milods. I thought it was weekly 45 milods. So therefore I mentioned I just dashed into it. I thought my lords is taking weekly list. So 45, I don't have any
Your
power.
thinking has been proved to be entirely wrong,
Lots.
isn't it?
The display board showed weekly 5, therefore I just rushed in.
Display board showed weekly fee. कौन वो?
Milods.
45 को से हम तो अर्जुन ही है तो
Arjun, next week is.
Milods.
हाँ weekly list का weekly list में तो सॉरी इशू थे लास्ट को
42
हाँ बराबर हम कंटिन्यू करिए तापरे पास ओवर नो यस मिस्टर साहू
मोर पास ओवर है
पासवर्ड ଆମେ ଗଡେଇ ଦବା ଠିକ ଗଡେଇ ଦବା ତାପରେ ପାସୱାର୍ଡ କରିବା that is the process I'm following for everybody. Why should I change? 42 के नाम तो
Weekly list item of 42.
के नाम छाड़ रख Radhi will take it up after recess. You will let us do one thing. Let us continue the list. 7-8 matter होची सरजो तापर पासवर्ड पुन रखिए Kali a lot of matters were passed over actually. And some matters were also orders matters were all over probably. But order 41 rule 11 was all.
Allow the modification petition. And in the main bail application, I have mentioned about the release of co-accused on the bail. Or 3 co-accused, all the co-accused released on bail. So reflect to maintain parity.
कितना item कितना?
Item 43.
Item 43 parity पे ऐड करो. Supplementary list item supplementary list sorry ऐड करो. Modification जाएगा हम जा रहे हैं ताकि ऐड करो है ना? कितना item?
Item number 42.
42, my lord, I am for the respondent. I have taken consent of appellant ଗୋଟେ note ତିଆରି କରୁଛି weeks ପରେ ଆସିବ ଏ ମୁସଲିମ ନା ସବୁ ଏପଟ ସେପଟ ଗୋଟେ note ନ କଲେ ହବନି
Correct. Is this matter on? As per the is this matter on?
weeks ପରେ ଗୋଟେ date fix
9 September in
9 September.
9 September. Fine. So blessed.
Item number 43.
Yes, item 43.
Passed over for the day.
All right, pass over for the
Item 44.
44 I am for the respondent.
pass over.
Item number 45.
45, can you take around next week?
Next week.
Well, I prepared.
This is matter in the week commencing 2nd September as paid for.
Item 46.
Pass over.
Item number 48.
Sir, I am for the respondents.
Pass over.
Item 49.
49 my lord.
RSA 450. By the defendant, my lord, that was disallowed by the trial court, but same was the reversed. That was allowed. So against both the appeals, he has referred 2 separate appeals. And the substantial ground is one. In both the this second appeal, substantial ground is one. Whether if a specific prayer is not made for recovery of the possession, can it order 7, rule 7 be applied or not? That is the only substantial question.
And that is the judgment of this honorable court.
Learned counsel for the appellant is present.
I'm not
appears-
appellant. I'm the respondent in the
None,
cases.
sorry. None appears for the appellant. On repeated calls. Learned counsel for the respondent is present. As a matter of last chance, on the last occasion also, there was no appearance from the side of the appellant. Is this matter in the week commencing 2nd September as last chance?
Item 50.
This matter, your lordship, asked me to formulate the substantial question of law.
In this case?
Yes, because your lordship indicated the. Peter, question, no, no.
No, there are two which are factual. I thought there are two factual. These two questions are purely factual.
Actually, what
Yes. Have you framed it?
Yes, I have formulated. I don't see it. Argue with the court. It doesn't make it. Would have to be case. When the plaintiff was granted an Amalnama Pata dated 14/1/42 for agriculture purpose and continued to possess the land on payment of rent till vesting, even after vesting continued to possess the land and has acquired the right to be recognized as a deemed tenant under the state as per section 8(1) of the OE Act, keeping in view of the admitted factual position, whether the learned courts below are justified in not declaring a plaintiff to be the occupancy tenant (riot) in respect to the suit land on the basis of the prayer for granting any other relief as per law. Because there is a specific provision in the CPC, Order 7, Rule 7.
Yes, molding the relief.
Right. Any of the relief. But here actually he has claimed adverse position, which is actually not correct. If your lordship looks at the factual position, here the suit has been decreed in part. Appeal has also been decreed to that extent where the trial court granted. Both the courts below held, I am in possession throughout, and injunction has been granted restraining the defendant not to evict me. But the fact, if your lordship looks at, it emanates from the fact that I got the Amalnama in 1942.
Yes.
I am continuing in possession, property vested in the state. So it was recorded in the name of the state. He has not taken steps to get it recorded. Continues to be in possession. And that is how the suit has been filed. And the court has accepted possession throughout.
So we'll frame this additional question of law.
Right.
In course of hearing and on perusal of the impugned orders, impugned judgments. This court is of the view that the following substantial question of law is required to be framed for better adjudication of the list. Whether the courts below were justified in not declaring the plaintiff as an occupancy tenant / royat in respect of the suit land in view of the fact that he was granted Amalnama Patta on 14/1/1942 for agricultural purposes, which he continued to possess on payment of rent till vesting and also thereafter. And as such, he acquired the right to be recognized as a deemed tenant under the state as per section 8(1) of the OEA Act. That's all. Relief, whatever relief is,
Sir, actually, interestingly, in this case,
Shall we take up for hearing today?
Yes, Somadhanji. I have not read it.
So, let sir begin.
Yes.
We'll keep it as part 2 next week or kung sila ko?
no, in the such hearing, part heard the
Oh.
because interestingly, I actually weekly goes, he has sold some properties in favor of.
Sir, you have to begin from the, I mean, you have to start from the beginning. I don't have.
No, I'm not saying anything. I'm not arguing it now. This plaintiff has sold few lands in favor of others. They have got their name recorded. Now, if you have directed him to, after hearing, of course, to record my name in the record of right, correct the record, that is enough for me.
No, was his name recorded in the tenant ledger?
Yes.
After vesting?
After vesting.
So why was the suit decreed in part?
Because court said, I'm seeking adverse possession. Adverse possession, court said, no, it's permissive.
Okay.
Obviously, if I deem tenant permissive, you.
Yes. नहीं ताले बर्तमान जो additional question of law frame है सितरा adverse position रही वो नहीं
दरकार नहीं
But in part, please this matter. Go. We commencing
9th September.
9th September.
Item 51.
Pardon, my lord. I am on behalf of Mr. P.K. Kuntia. Kindly pass over this matter.
Pass over.
Item
Bless
52.
May I please, your lords.
Yes.
Let item 52.
The name of Sri Somadarsan Mahanti be deleted from the cause list. Sorry. Yes.
My lord, in this matter, the plaintiff appellant, that is Sushant Kumar Panda, and his elder father was the owner of that said land since 1939, and he has been paying the land revenue till now. Still, in MS ROR, it has been reflected the name of the opposite party, and for that we got the favor from trial court, the learned trial court. Then in RFA, additional session judge, he has reversed the judgment, and now we are here for RSA. And in this court also, we have got the favor, like in IA number 8154/2022, one status quo has been given by this honorable court, and I'm humble request to continue that status quo, lordship.
No, why? The matter is ready. Why don't you argue? We'll dispose of.
Actually, my lord, we are relying upon two judgments, like Achyutananda Swami and.
No, judgment will come later. First, place the facts. First, place the facts.
My lord, I need some more preparation. That's why I need.
How come you are ready with judgments, but when it comes to facts, you are saying that you need time? Ago court, ago fact, ago law. Mujani needs a proverbial chicken egg story. Which is first? Sir, the facts are first, obviously. Then the law is to be applied.
Yes.
So you are ready with two judgments, but you are not aware of the fact.
Yes, my lord, I am ready, but still I need.
As requested, list this matter in the week commencing
9th September.
9th September. All right, 9th September, interim order to continue.
Published.
Item 53.
So 53 is for hearing. So I'll argue that. The two admission matters are actually passed.
No, sorry, you audita to fella पर पुणे pass over लखी हो. Audita मतलब रहला.
Hearing कॉल इटा चलियो.
चलू. समझे चलिए.
State is a party, in fact.
A party what other private party.
Private party, Mr. Bhuya.
Other problem which private actually. Mr. Bhuya is appearing. So actually, this matter requires to be sent to the mediation center.
Let him be there. Let him appear.
Reason being, why I say so? Sir, the government wanted to have a hatter. They have opened one hatter and that what's the other hat? Mahangana Road. So hatter was functioning. This other person claims that you are holding the hatter on my land. They say no, it's a government land. That's the dispute. So measurement was held. A substantial portion actually belongs to him. I was suggesting the government, the collector, so why don't you this RMS? So why don't you give another piece of land to him someplace so that he can be compensated with the land and his land can be utilized for the public purpose. This is for public purpose, RMS, having the daily market, all that.
Regulated market.
Regulated market committee. So I've told the collector, he said if the other side agrees, then we can go for a settlement.
Okay. So let him appear then.
This is the sum and substance of the matter.
Is this matter in the week commencing? 17th September as played for.
ଆପଣଙ୍କୁ ଟିକେ ପଚାରନ୍ତୁ ମୁଁ ତ RMS ଥ୍ରୁରେ କହିଥିଲି inform them.
Yes.
Item 54.
On behalf of Mr. B.K. Rautray, let kindly take up tomorrow.
Alright, pass over.
Item 55.
Respond.
It can be disposed of. My other side, I have told him it is without jurisdiction. Declaration that she is the legally married wife of so and so. It was dismissed. Appeal was filed. In appeal, it was decided. But during the pendency of the first case,
the notification,
before the trial court, the family court established,
notification was issued.
it should have been
So he
said.
seizes jurisdiction.
That is the only issue to be decided in this case. I have told us to come and
We'll take it up next week then. Probably. Next week, weekly list. Next week, as per for. All right. Pass out.
interim order is
Yes. Pass over.
So item number 1.
May I please do last? That the plaintiffs are the appellant against the reversing judgment. The suit was filed for permanent injunction and for a declaration that the order passed by the Tahsildar in Tojimis case and in a mutation case by recording the property in the name of the defendant to be declared as void. On that basis, the case of the plaintiff is like this below. The plaintiff was recorded in the MS record of right. The property was recorded in the name of the father of the plaintiff. That is 13 dismills of land. And he was in possession over that property. And it was recorded in the major settlement record of right. And while he was continuing in possession, the defendant tried to enter into the suit land by cutting the reach. So therefore, he filed the suit, seeking for a relief of permanent injunction and for a declaration on the basis why he has entered into possession, or tried to enter into my possession, on the basis that in a Tojimis case, the Tahsildar has corrected the record of right which are prepared by the major settlement authority, purported to be under Rule 34 of the Servant Settlement Act, the Servant Settlement Rules.
Toji is for non-payment of rent, I believe.
Non-payment of the rent, but that Tojimis case was started and correction was done, and the map was corrected by the Tahsildar, which is totally outside his jurisdiction. Once the major record of right was prepared, if anything happened after the preparation of the record of right, on the basis of the civil court decree or any order of the competent authority, then the Tahsildar is authorized under Rule 34 to correct this. But if a record of right has been prepared
on the basis of the act happening prior to the publication of the record of right, Tahsildar has no jurisdiction to touch such record of right. If anybody is aggrieved by that record of right, then they file the revision before the under section 15 for correction. However, the Tahsildar corrected the same, so therefore we file the suit for declaration that the Tahsildar order is void and for permanent injunction, since the property has been recorded under Sthiti 1 status in my hand. The trial court framed two issues here that you can see. To that respect, issue number 3, yes, and issue number 4. The issue number 3, the trial court, you can see the trial court judgment. Is the order of the Tahsildar in Toujimis case number 12297 and the order of the Tahsildar in mutation proceeding is void. 4, whether the plaintiff is entitled for a decree of demarcation in respect of the suit land. And 5, if the plaintiff is entitled for a permanent injunction. These are the 3. These 3 issues are the important issues for consideration.
You can come straight to the running page 60, paragraph 12, where he has given his finding.
Yes, ma'am.
Appeal to the court says.
Paragraph 11, euros.
Paragraph 11, I don't think. I think paragraph 12 is the summation of whatever he has found out.
Yes, ma'am.
Paragraph 12, you can place it. We need not go through the oral testimony. We will just, he has discussed.
Paragraph 12.
Yes.
I peruse the record as sworn by both the parties, compared the same with the pleadings of both the parties and their oral testimony. In my considered view, he has considered all the pleadings of the parties and the evidence of the parties in paragraph 11 and 12. In paragraph 11, in extenso. Then in my considered view, the ROR in respect of major settlement plot number 73, 74 and 75 are prepared basing on the existing fact prior to the publication of MSROR. This is very most important. MSROR, the mention of 13 dismissals of land in respect of MS plot number 73 is made after due inquiry and after considering the registered sale deeds in favor of the defendant executed by Konduri Das in the year 1969. So the Tahsildar has no authority to correct such ROR in the year 1998. As per the decision, Supra, as neither Konduri Das nor his legal heirs were made parties in mutation case number 316 of 76, the order passed in the said mutation case is not binding on the same on them. So both the orders are void. Hence, this issue is answered accordingly. After considering all the evidence, he has recorded this particular. So far as issue number 5 is concerned, your lordship can see, so the issue of the relief with regard to permanent injunction. It is an admitted fact that the major settlement plot 74 stands recorded in the name of the father of the plaintiff. The major settlement ROR, which is Exhibit 1, also supports the same. So it reveals that the plaintiff has a valid title over the suit land. The oral evidence of PW1 and 2 reveals that PW1 is in physical possession over the same. So it will be convenient on the part of the plaintiff.
It will be inconvenient.
It will be inconvenient on the part of the plaintiff if permanent injunction is not granted to him. But the same injunction order will operate after due demarcation of the suit land. Hence, this issue is answered accordingly. He has directed for demarcation in paragraph issue number 4.
So the suit was decreed.
Suit was decreed. Thereafter, your lordship can see the appellate court judgment. The appellate court, that without discussing any evidence and without going through the materials on record, straightway in what manner the appellate court judgment has been delivered, your lordship can see. He has recorded what is the grounds taken in the appeal memo. Recorded the case of the parties he has described in paragraph from paragraph 2 to paragraph
I think paragraph 9.
Paragraph 9. And your lordship can see, it does reflected the issues, and thereafter,
paragraph 9 will do.
Your lordship can see paragraph page 37, running page 37.
Yes.
From issues, thereafter from 36.
Yeah, why issue to
They only protect the what is the grounds taken in
taken in your appeal memo.
Appeal memo. Thereafter on paragraph 9, your lordship.
That is what I'm saying.
After hearing the Lord and Counsel appearing for both sides, and on perusal of the averments of the parties, evidence adduced in this case, both oral and documentary, this court comes to the finding that the suit for permanent injunction and demarcation is not maintainable. In view of the challenge to the case of the plaintiff respondent and the defendant side in the WS raised serious contention regarding the title of the plaintiff.
Which means that since you should have also claimed title.
Also claimed title. Which is not correct.
Simpliciter
permanent injunction simpliciter is not maintainable.
That is what he says.
That what he has said, Lord, without discussing any evidence, Lord. Lord, I am citing the decision which he has relied upon, the trial court has relied upon. I am citing in which circumstances the injunction suit is maintainable, even without claiming the title.
And there's a decision of this court, Honorable Justice G.B. Patnaik, directly on the point. Whether a suit for permanent injunction
simpliciter is maintainable if a person is in possession over the property.
That has to be
found that they are in possession over the property, asserting his own title over the property.
Obviously.
If he is disputing the title in an injunction suit, the question of title can be gone into.
Only for a limited purpose.
Yes, Mula. Elaborately, that the Honorable Supreme Court in 2008, Volume 4 SEC has considered all these aspects. There is absolutely no discussion about the as a court of fact, last court of fact. We have not taken into consideration any of the evidence on record, and one issue has not been dealt with by the appellate court at all. Whether the order which was passed in the Tojimis case by the Tahsildar, in which the trial court has given the after considering the evidence has come to a definite finding. So that order is not maintainable in the eye of law. That order is not sustainable in the eye of law, and it is totally without jurisdiction. Appellate court has not dealt with that aspect at all in the appeal. He has only gone to the question of injunction, and after putting the grounds in the appeal memo and the respective case of the parties without discussing any evidence, suddenly come to the conclusion that since it is a simple suit for permanent injunction, so therefore it is not maintainable. Paragraph 30. That your lordship can see paragraph 12.
Yes.
On the paragraph 12 of that judgment. On the contentions urged, the following questions arises for our consideration in this appeal. Your lordship got it?
Yes.
Paragraph 12.
Yes, yes.
On the contentions urged, the following questions arises. The following questions arises for our consideration in this appeal. What is the scope of a suit for prohibited injunction relating to immovable property? Whether on the facts the plaintiff ought to have filed a suit for declaration of title and injunction. Whether the High Court in a second appeal under Section 100 CPC could examine the factual question of title, which was not the subject matter of an issue, and based on a finding thereon, reverse the decision of the first appellate court. It is not requires for consideration before this honorable court. Only question is question number 1 and 2.
Yes.
The general principle as to when a mere suit for permanent injunction will lie and when it is necessary to file a suit for declaration and or possession with injunction as a consequential relief are well settled, we may refer to them briefly. Where a plaintiff is in lawful or peaceful possession of property and such possession is interfered or threatened by the defendant, a suit for an injunction simpliciter will lie. A person has a right to protect his possession against any person who does not prove a better title by seeking a prohibitory injunction. But a person in wrongful possession is not entitled to an injunction against the rightful owner. Where the title of the plaintiff is not disputed, but he is not in possession, his remedy is to file a suit for possession and seek in addition, if necessary, an injunction. A person out of possession cannot seek the relief of injunction simpliciter without claiming the relief of possession. 13.3, where the plaintiff is in possession, but its title to the property is in dispute or under a cloud, or where the defendant asserts title thereto, and there is also a threat of dispossession from the defendant, the plaintiff will have to sue for declaration of title and the consequential relief of injunction. Where the title of the plaintiff is under a cloud or in dispute and he is not in possession or not able to establish possession, necessarily the plaintiff will have to file a suit for declaration, possession and injunction. So these are the distinctions. If he is in possession and he is asserting his title, and you have failed to prove the possession of the title over the property, merely because you are disputing its title, it cannot be said that the injunction suit is not maintainable. You have to prove that you have a better title over the property.
Yes.
But that there is no finding by the appellate court. There is no such finding recorded by the appellate court on assessment of the evidence on record. Appellate court has simply gone to the principle that the injunction suit is not maintainable without claiming title.
Yes.
That too without discussing any evidence on record. And so far as the other issue is concerned, with regard to the order passed by the Tahsildar in Toji's case and the mutation case, the appellate court, by discussing the evidence on record and by elaborating and also the taking into consideration the position of law as decided by this honorable court, and he has referred to two decisions. By referring to decisions, has said that since it is on the basis of the fact which was prevailing before the publication of the record of right, and the record of right has been prepared, thereafter the Tahsildar has no jurisdiction to touch that record of right and correct it. That part of the finding which has been arrived at by the trial court, that has not been discussed at all by the appellate court. The appellate court has to, the principle of the appellate court, how the appellate court will deal with a matter, if he is going to reverse the finding of the trial court, then he has to discuss the reasoning which has been given by the trial court, and why this reasoning is not acceptable, he has to give the reason specifically. If he is going to reverse the finding of the trial court, that is the principle. Here there is no discussion, nothing, and by quoting only the grounds in the appeal memo, suddenly jump to the conclusion that the simple suit for injunction is not maintained. So therefore, the judgment which has been passed by the appellate court, that is totally unsustainable in the law, and it requires to be set aside and by confirming the judgment of the trial.
Yes. Yes, Mr. Mahapatra.
So my learned friend must refer to the facts. Because I am not reiterating the facts, but I am only referring to few of the legal proposition. Thereafter, my lords, I will go into the facts, the relevant facts only in connection with those issues. But my learned friend referred to that decision of 2008, have been AIR, my lords. So paragraph is not telling. My paragraph number 10. Their paragraph
12.
Paragraph 12. Paragraph number 10 row to question the Honorable Supreme Court laid down three propositions. Three questions. Three propositions. Paragraph 11.3 ମୋର ଅଛି ଏଟା
এটা 13.3 ଆଉ କଣ?
ଆଜ୍ଞା 13.3
Where the plaintiff is in possession.
ହଁ ସେଇ ଗୋଟାକ ମୁଁ ଖାଲି ପଢୁଛି
ପଢ।
where the plaintiff is in possession but his title to the property is in dispute or under a cloud. Well, my learned friend all along says there is no dispute, there is no dispute, there is no dispute. The very word is used that there if that is there is a dispute, it involves a dispute. Or under a cloud, or where the defendant asserts title thereto. And there is also a threat of dispossession from the defendant. The plaintiff will have to sue for a declaration of the title and consequential relief of injunction, where the title of the plaintiff is under a cloud or in dispute, and he is not in possession or not able to establish possession. Necessarily, the plaintiff will have to file a suit for declaration, possession, and injunction. Then the subsequent paragraph. We may, however, clarify that a prayer for declaration will be necessary only if the denial of the title by the defendant or challenge of to the plaintiff to title raise a cloud on the title of the plaintiff to the property. A cloud is said to raise over a person's title when some apparent defect in his title to a property or where some prima facie.
Exactly. This is what I wanted to. I kept quiet for so long. Anybody can deny in a written statement. All facts are denied. That will not be denial or casting a cloud over the.
Yes.
So this is what I'm waiting for.
So my humble contention is
that you have to show from your written statement.
That my written statement, I don't have a copy because it is an arbitration stage, and my lords have formulated the point. I'm referring to the judgments only, my lords, because I don't have the.
No, we'll find it out from the judgment
itself. My lords, my humble contention is this. The legal proposition is very clear. If there is a dispute concerning title, and we are coming up with a specific pleading.
It's an actionable dispute in the sense that there is
actionable dispute. It is an actionable dispute. I am stating something which is there itself.
Yes.
It itself throws a cloud about the title. Then the plaintiff is to assert title followed by possession. Here in this case, the prayer is for permanent injection in respect of the property. Well, before I'm entering into the fact of property. So far as the declaration, it is in respect of miscase minors, that Kauti miscase and mutation miscase. I am not on there. If the suit is maintainable, thereafter we will find that this is there or not. Here in this case, my humble contention is that the suit in the present form for a permanent injection is not maintainable on the ground that the title in respect of that property is seriously disputed, referring to each and every facts. That is what the finding of the trial court also, not finding, the trial court referred to that. Well, kindly glance to the trial court order.
Yes.
Well, paragraph number 2 of the judgment, well, page 50. Well, page 50, paragraph number 2, this is the plaint story.
Yes.
Plaint story in nutshell, would I read that? Will permit me.
Please.
The plaintiff story in nutshell is that the suit land is the parental property of the plaintiff. In the MS settle operation, it was recorded under Khata number 156, plot number 74 for an area 30 decimal during lifetime of the father of the plaintiff. He was in peaceful possession thereof. The defendant has his land to the east and south of the suit land. Taking advantages of the simplicity and old age of the plaintiff with the malified motive to grab the suit land, the defendant caught the southern and eastern side reach of the suit land with a view to dispossess the plaintiff. The defendant also gave open threat to dispossess the plaintiff. When the plaintiff asked the defendant the reason of such threat, the defendant discloses that his land has been amalgamated in the land of the plaintiff. When the plaintiff proposed to measure the suit land by a local law mean on such and such date, the defendant refused the same. The defendant further, in absence of the plaintiff, initiated one miscase and one mutation proceeding in respect of the suit land and own the same. But the order of the such miscase and mutation proceeding are illegal and void. The Tahsildar Bastepur is not competent to correct the ROR on the strength of the said miscase and mutation proceeding. So the plaintiff has come up with a present suit with the above prayer. Then the case of the defendant. The defendant, on the other hand, denies the claim of the plaintiff. The stand of the defendant is that though the miscase number such and such and in the mutation proceeding, the order have been passed in his favor, and the order have been passed basing on his sale deed, and his possession. The stand of the defendant is that the suit land along with on the undisputed land is under CS Khata number 635. That the detail of sequence begins. The CS tenants was Kelu Das.
Yes, Keludas.
Keludas and others. The land under CS Khata number 635 went to the hand of some of the other persons in place in course of time by eliminating the right title interest of Keludas over the suit Khata. Out of the suit Khata 635, plot number 139 for an area of 59 decimil, Sudhakar Manti had sold 19 decimil to the father of the plaintiff. 19 decimil. Namely, Konduri Das. Father of the plaintiff is Konduri Das. He sold it way back in the year 11/8/1941. Konduri Das was in peaceful possession thereof. Konduri Das sold 19 decimil of the land to the defendant on 27/3/1979 under registered sale deed and delivered possession. Since then, the defendant is in possession over the suit land with the knowledge of the Konduri and his legal heirs. Out of CS plot number 139, Panu Das had purchased 22 decimil. During MS settlement, 20 decimil of land was recorded under MS Khata number 4640, plot number 75. After death of Panu Das, his legal heirs, namely Gajendra and Manmat, sold 22 decimil of land to the defendant on 13/3/1985 and delivered possession. The MS map in respect of MS plot number 75 has been wrongly prepared as acre 016 decimal, acre 016 decimal, even though the ROR has been prepared for area acre 022 decimal. They are multi pinches. And physical possession is also over area at 22 decimal. So the defendant caused the MS map corrected by the Tahsildar Bastepur. Only correction of the map boundary concerning map boundary. The dispute MS plot number 74 for an area of 13 decimal has been created from out of plot number 139 and 140. And area acre 012 decimal of the land has been brought from CS Khata number 139. Acre 01 decimal from land brought up from CS Khata number 140. This MS plot number 74 under Khata number 156 has been wrongly recorded in the name of Konduri Das. The said 19 decimal of in the name of the defendant, rest 6 decimal of land out of 19 decimal has been wrongly amalgamated in MS plot number 74 or 1214, plot number 74, 5848. And defendant rather claimed that he had purchased such and such land, 1 acre 07 decimal land from Baidar Das under CS plot number such and such in 3 registered sale deed dated at such and such and such and such. From thinking of this, out of this said acre 1.07 decimal north had been amalgamated in MS plot number 74. Accordingly, MS plot number 74 has been measured as 13 decimal. The Tahsildar Vasudevapur being in physical possession, the report of the Amin and RI has corrected the ROR and put the 7 decimal of land under Khata number 122993, plot number 74. Accordingly, the disputed plot, acre 130 decimal land is recorded in mutation ROR Khata number such and such for an area of 6 decimal and miscase Khata number such and such for an area 7 decimal. The defendant claimed that he is paying rent for the said land. So in this circumstance, the defendant claims his dismissal of the suit. My humble contention, all that reading of all these things, sequence of events from 1941 and onward, it itself indicated that we are the property, the title of the property is under a cloud.
Yes.
Is under a cloud. In such a contingency, if you straightforward and come and say, well, there are a lot of things, because in piecemeal, there were purchased at different times through different deeds. So question is, I am justifying this, how I am entitled to this and how I got it. So Tauji miscase and all these things have happened after purchase of the last purchase of the property. So whether it is before or after that, I have to check it. I have not checked it up, and I have to check it up before settlement, after settlement. But one my learned friend says this is the law. If it is before settlement, then 15B. If it is after settlement, the Tahsildar can do it. Here in this case, what I found, the last portion of the property which was purchased in 1985, when the suit was settled in favor of, because there is a sale in 1941, probably they were referring to the Sabak settlement, CS settlement, cadastral settlement, probably they were referring to cadastral settlement. So it itself indicated to go through cadastral settlement many things, so as to come to a conclusion that you have a title or not over that property. I am disputing your title over that property. When title of the property is under dispute, when the sequence of events says that these are all required for a declaration, and your declaration is only in respect of these two order passed, not in respect of the property. I understand a case. Suppose I am in possession of a property. Somebody comes and says that I am in possession of property. I want to evict you. Simple possession. There is no dispute concerning title. I am admitting his title. All right, injunction can be maintained. Even if you have a better title, the injunction can be maintained. But here in this case, the whole total dispute concerning title is under shroud. It is under the cloud. And that is what my humble contention, that the judgment of Honorable Supreme Court, so far that particular clause, these two clauses I read, I have come up with a clean hand. I have categorically stated that we are disputing the title, and you don't have a title, we are denying your title. In such a contingency, when we are denying a title, you say that I perfect a title. You could have converted it. Why think could have had that been proper advice, could have converted the suit for a declaration with respect of the property after getting the written statement. That scope was very much there. That you have not invoked. Now makes the order of the Learned Appellate Court. Learned Appellate Court, what I understood, that it has not gone into the matter only on the ground that suit for injunction simpliciter is maintainable in the present fact and circumstance of the case or not. If
yes,
suit fails on that ground, then two contingencies may come. One, he may go for a separate fresh suit for claiming declaration, or concept
will it be maintainable?
It's a declaration
Constructive res judicata.
Exactly. This my second point is you have to ignore the concept of constructive res judicata. Constructive res judicata. So constructive res judicata, but where the prayer is not at all there. You all along asserted this is your property. We deny your title. Now question is it is now title is under dispute. In such a contingency, you have not resorted to this option available to you. And the suit fails for that reason.
Yes.
If suit fails for that reason, examining other contingencies does not arise. Then you have to come up remedy, whether a suit or otherwise. I am the last one to give suggestions in respect of that. Whether constructive res judicata will apply, how can you ignore that, avoid that constructive res judicata or get it done matter, that is a different concept. But Learned Appellate Court, wise enough, could find out these two, find out that point. Okay. And this very, very sharp point. Here, dispute lies. Here, the title is not a cloud. There is a lot of things to be stated. And without examining all these things in a true suit for a declaration, in absence of prayer for declaration, injunction simpliciter is not maintainable. And this judgment of Honorable Supreme Court squarely covers the contingency.
All right. I am closing it.
But I am giving a short reply.
Appellate court
अब किसी ना ये तो point हो.
आज्ञा मुझे appellate court रे ते जो paragraph बेसिक मार्क होना है appellate court रे जितनी की paragraph रे जो जाए दे चली से paragraph number
that we have already read.
नहीं
I was already read.
ता परा paragraph पढ़ा ता परा paragraph रे very nicely he couched why paragraph 9 पर 11 the general principle टा कौन law proposition टा कौन से law proposition टा जाएगी से जाई चंद जब देखो चंद suit is not maintainable per se. So examining all these things is academic.
That I've seen. That he said it will be futile exercise.
Futile exercise, academic, and that so far as that permanent injection, simpliciter, on the learned Lower Appellate Court, paragraph 10, starting from paragraph 10, 11, 1, 2, 3, and then 11, has in detail narrated why he has resorted to this, why he had pointed out this. I'm reiterating for the purpose of, for the sake of argument, that here in this case, title, we are seriously disputing, giving sequence of event from 41, and when you found that the title is under dispute, you could have carved out remedy in accordance with law.
Yes.
You have to fail, you have to stand on your own leg, you have to fail.
Very limited reply.
Very limited reply. Let the relief prayed for in the suit is twofold. On what basis they are claiming title? They have made the purchase in 1941. Up to 1985, they are showing that the suit plot involved in the suit is learned the Khata number 56, plot number 74, area 13 decimal. That is the suit plot over which I am claiming for injunction, and for a declaration that the correction which has been made in respect of that plot by the Tahsildar, that is, Tahsildar had no jurisdiction to correct that, and it is void. In order to justify the correction, they put forth all these questions, all these facts, that 1941, the CS plot, they are referring CS plot, and some plots which are not related to this plot. And out of that, the property has been recorded, 19 dismills we have purchased from that Magunidas. And that out of that property, 13 dismills has been recorded in plot number 73 in our name. And other plots were amalgamated in the plot of the petitioner. That is 13, area 13 dismill has been carved out in 74 by amalgamating our plots. And the correction was done by the, on what basis? That correction was done by the Tahsildar, and it has been corrected. On the basis of the order passed by the Tahsildar, they are claiming title over the property. They are purchasing it from in 1985. Thereafter, the record of right was prepared, Exhibit 1.
Yes.
My claim in the suit is very specific, that this property has been recorded in my name, and I am the title holder of the property, and on that basis they are interfering in my possession. So therefore, I am playing for the decree of injunction.
So after order of Tahsildar means after order of Tahsildar in the Toji case.
In Toji case, if the order of the Tahsildar is without jurisdiction, where is the basis of title?
Yes.
If the order of the Tahsildar is totally without jurisdiction, and the order passed in the mutation case, that is completely non-honest in the eye of law, which has been held by the trial court. And without going to that question, straightway coming to the finding that since it is a simple suit for permanent injunction, and the defendants are disputing the title, so therefore the suit is not maintainable.
Correct.
Without giving any finding to that aspect.
Only one sentence I will add, my lords. So far as the 19 deeds,
And your lordship.
the category.
Yes, sir.
Oh, sorry.
And your lordship can see the way the appellate court has dealt with.
That have already.
Yes, your lordship has already seen. This is not the appreciation of the evidence, and this is the rule of practice, Lord, that the trial court, appellate court, while dealing with the judgment passed by the trial court and reversing it, will deal with the matter in this manner. While you are going to reverse the finding, I am again repeating my submission, while you are going to reverse a finding recorded by the trial court, you must meet all the evidence and thereafter come to your independent finding. That for this reason, this is not acceptable. This is the rule of practice while dealing with a judgment of the trial court by the appellate court, with the last court of fact.
Correct.
Only I think one.
And your lordship, you see another paragraph. I am just referring to your lordship. Where I am placing before your lordship. That paragraph 21 of that judgment. 21 of that judgment. So far as the Touji case is concerned,
Yes.
before referring to that, I'm just placing
Well,
before your
got
worship.
your point, Mr. Sahu.
Yes,
Got your point.
But
Only thing.
my learned friend is saying that since there is a cloud over your title, and we have created a cloud in your title by filing the written statement, so your suit for injunction is not maintainable. That is not correct. That is not the correct position of law.
Probably my learned sin brother has not taken what I say.
That your
When the cloud comes.
Paragraph 21. Paragraph 21 of the judgment. I see it, 2008.
See 2008.
Yes. Paragraph 21. To summarize the position in regard to suit for prohibited injunction relating to immobile property is as under. Where a cloud is raised over the plaintiff's title and he does not have possession, the lawsuit can mark it, does not have possession, a suit for declaration and possession with or without a consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a cloud, the lawsuit can mark it. Cloud, that he is out of possession. He has to sue for possession with a consequential injunction. Where there is merely an interference with the plaintiff's lawful possession, threat of this possession, it is sufficient to sue for an injunction simpliciter term. So therefore, on what basis you are claiming your title, since it is totally void in the eye of law, that cannot be taken into consideration for this purpose and placing a simple, relevant portion of the trial court judgment. How the trial court has dealt with this aspect. So also can see the paragraph 9. Paragraph 7 and 8.
Paragraph 7, yes.
Yes, ma'am. During cross-examination, PW1, the plaintiff denies to, in his evidence has stated that he had rectified the MSROR in the court of the Tahsildar, Basudepur. He has filed title, Touji case number 122/97 and recorded 7 dismissals of land in his favor under Khata number 1229/932, plot number 74, out of plot number 74. 6 dismissal has been recorded in that on the basis of that mutation case. DW1 has proved the same as Exhibit F. According to DW1, he has purchased 19 dismissals of land from the father of the plaintiff under registered sale deed and was delivered with possession in the year 1969. Well, also can mark it. This property he has purchased in 1969 and the ROR was prepared in the year 1985. Exhibit 1. He proved the sale deed under Exhibit A under MS operation. He got the ROR mutated in respect of 13 dismissals of land out of 19 dismissals, which is under MS Khata number 1214 and MS plot number 73. He has further purchased 22 dismissals of land from Gajendra Das and Manmad Das, son of a Pranabandhu Das, from MS plot number 75 and was delivered with possession, but the same is as per MS map for an area of 16 dismissals. Again, he has purchased 1 acre 7 dismissals of land under 3 sale deeds, sale deed number so and so, from Sahu family. DW1 has marked the sale deed under Exhibit C, D, and E respectively. In MS map, the said 1 acre 7 dismissals of land has been shown as 1 acre 6 dismissals. DW1 claims that MS plot number 74 for an area of 13 dismissals has been created by taking 6 dismissals from MS plot number 73, which ought to be 19 dismissals, 6 dismissals from plot number 75, and 1 dismissal from CS plot number 140. During cross-examination, it has been brought out that Konduri Das, the father of the plaintiff, died 10 years after he has purchased, and he cannot say who are the parties in the miscase which has been filed before the Tahsildar Basudepur. He expressed his inability to say the miscase number and mutation case number on the ground that his Gumasta, Bhagirathi Das, was looking after them DW1 further denies to the suggestion that he had applied before the MS authority to record the land as per possession and that Bhagirathi had given evidence in objection case number 609. There was an objection case prior to before the settlement authority. And in that objection case, this property was recorded in my name. And they were the party to that objection case. The trial court has discussed all this. DW1 could not say whether Pranabandhu had filed any case showing wrong recording in MS map in respect of which 22 dismissals of land under MS plot number 75 or not. He also does not remember whether the sale deed executed by Pranabandhu by Panu in his favor reflects that the area of a 22 dismil is shown as a 16 dismil. In the MS map, DW1 further admits that he has not filed any suit to declare the MS map wrong. He further states that he has not taken delivery of possession as per measurement. After mutation, he came to know that the area under MS plot number 73 is 13 dismil instead of 19 dismil. DW1 could not say when he came to know about the reduction of 6 dismils of land from MS plot number 75. Similarly, DW1 also did not take delivery of possession from Sahu family in respect of 1 acre 7 dismils of land as per measurement, though he has purchased the same under 3 sale deeds. He knew about the reduction of 1 dismils of land about 3 to 4 years back. DW1 further states that the Toujimis case, the Tahsil Amin had not visited the spot where Lasukan market. All this evidence he has taken into consideration. The private Amin had visited, according to DW1, in this case, the son of the Konduri were not made parties. The London Council for the defendant strenuously urged that the Tahsildar Basudepur in Toujimis case number has directed to record 7 dismils of land from Khata number 156 under plot number 74 in the name of the defendant, basing on which exhibit F has been created. So also the Tahsildar Basudepur in mutation case number so-and-so has created the plot 74 by 5848 for an area of 6 dismils under Khata number 1214 in the name of the defendant. These orders of the Tahsildar have been done in official capacity basing on the physical possession and the registered sale deeds in favor of the defendant. Then, on the other hand, the London Council for the plaintiff draw the attention of the court to the Exhibit 6, which is the application for correction of ROR made by the defendant before the Tahsildar Basudepur in this case number so-and-so under Section 34E of the OSS Act. He further drew the attention of the court to the order of the Tahsildar Basudepur in this case number 122 by 97 on 24/1/98, which is in Exhibit 5. The submissions of the London Council for the plaintiff is that the Tahsildar Basudepur is not competent to correct the ROR which has been prepared basing on the fact which exists prior to the publication of the MS ROR. In this instant case, the admitted fact that the defendant is that the admitted fact of the defendant is that he had purchased the land from Konduri Das on 27/3/69. Your Lordship can back with. It is also admitted by the defendant that he had obtained the ROR in respect of the said purchased land, which is under MS plot number 73 for an area of 13 dismil. He has also admitted that his son and Gumasta were looking after the MS operation. So, the MS authority had prepared the MS ROR in respect of the purchased land of the defendant from Konduri. After being satisfied, he has recorded only 13 dismils of land in his favor. DW1 has also admitted during trial that he had not taken delivery of possession from Konduri. The one admission that he is not in possession. Konduri as per measurement. So, recording of 13 dismils of land instead of 19 dismil in the name of the defendant under MS ROR under MS plot number 73 is within the existing fact prior to the publication of the ROR. So, this ROR cannot be corrected by the Tahsildar under Section 34E of the OSS rule. This is also held by our own High Court in a division bench in a case between so and so. He has relied upon 1997 1 OLR page 13. And your lordship can then after we are assessing all the evidence, your lordship can turn to running page 58. 58 last paragraph. Let sentence start with in these circumstances when the defendant had. Let page 11 of the judgment, trial court judgment. Page 11 of the trial court judgment. 12. Paragraph. Yes, my lord. Paragraph 11. Paragraph, big paragraph. Let sentence start with in these circumstances. Yes. In these circumstances, when the defendant had not taken delivery of possession on measurement, now he cannot claim that MS map is wrong or 6 decimals has been amalgamated in plot number 74 because MS plot number 74 is 13 decimals as per MS operation. In the said MS operation, the MS plot 75 was measured as 22 decimal. So the question of amalgamation of 6 decimals of land, MS plot number 75 in MS plot number 74 is absurd. In these circumstances, the plaintiff claims that the order of the Tahsildar in this case number so and so should be declared void. So therefore, whatever finding has been recorded by the trial court, that is based on the assessment of the evidence on record by taking the pleadings, the evidence of the parties, and after elaborately appreciating the evidence, he has come to this finding. Where the trial court, where the appellate court has adopted this principle, he has not referred to any evidence. And your sole basis is disputing my title is that the order passed in the Touch case. Correct. Once that Touch case is void, my suit for injunction is maintainable because I have the title over the property. And prima facie the court found on assessment of the evidence that I have the title over.
ମୁଁ ଖାଲି ଗୋଟିଏ ସେଣ୍ଟେନ୍ସ କହିବି cloud comes if somebody disputes. Unless somebody disputes, cloud doesn't come. If I've gone through all these details, if these details are required and it could have adjudicated when suit so far a declaration is concerned. Well, kindly visualize one thing.
Yes.
Declaration so far that if suppose there would be a prayer for declaration. So the lauded trial court could have examined all these detail. I could have also stated evidences in that light, giving the detailed particulars.
I have understood your case. Your case as well as Mr. Sahu's. How further?
Yes, only खाली गोटे line.
I will say गोटे line कोई के पर 3 थोड़ा line कोई.
नहीं नहीं गोटे line कोई.
गोटे line कोई की कितने थोड़ा कहले आपण कोई.
कोई एटा.
हां. ये आप या पूर्व कहले गोटे सेंटेंस.
नहीं ये गोटे line. para 10 गोटे line.
कोना
last line. सेते लिखा है देखो तो the registered sale deed in favor of the defendant. 2 possession and registered in favor of the defendant.
Right.
My humble contention I have already stated.
Hearing concluded, judgment reserved. Parties may file their note of submissions and memo of citations even within a week.
Yes.
Yes. Tapre?
The lordship, I am only referring to Rule 34.
Only.
Rule 34. On what basis the Tahsildar on?
No, I'll look into it.
Yes,
look into
Rule 34.
So item number 9.
About that time.
I will only rely on that this one only.
So I got persuaded to give answer to that. That is part by 7 meeting. Sorry, my lord side.
Item 9.
I will let him take it after 2 weeks, madam.
Yes.
After 2 weeks, madam. Taken.
This is for
9. Here is a case, my lord. It is against the confirming judgment, where my title has been declared and the decree has been passed for recovery of possession over the land.
No, why do you want time? This is for substitution. We can ask the substitution.
Your lordship allow the substitution and kindly fix a date for hearing. That is my anxiety because I have filed your lordship appoint me as a receiver. Appoint them as a receiver. And directed them to submit the account.
No, already appointed.
No, they have appellant were appointed because they are in possession. So therefore, this court has appointed them as a receiver and directed them to submit the account, but they did not submit the account.
Why?
Did not submit the account. So therefore, I have filed an application for discharge them to from the receivership.
Yeah, you first satisfy the court. Why are you not depositing? Why are you not furnishing accounts?
No account has
I
been
have
furnished.
furnishing my lord, but Mr. Mishra is absent, my lord. That is
No, that's all right. You.
I'm saying.
I will adjourn the matter.
Yes,
Why will you not? Why will you violate the order of this court? The appointment of receiver is it's a very harsh remedy.
Yes.
It is always attended by certain conditions, and those conditions, if they are violated, then I will discharge you.
My property and the decree of recovery of possession has been granted, but they are continuing in possession and running a petrol pump. They are earning 2 lakhs per month.
No. I am keeping it to next week. You satisfy the court. Where is that order of granting receiver?
That 4/9/2019. 4/9/2019. IN number 232 of 2019.
4/9/2019.
Yes, ma'am.
Sir,
order number 9. Order number 9 dated 4/9/19.
4/9, yes.
Considering the rival contention of the parties and as this court finds there is admission by both the parties regarding possession of the disputed land in question by the appellant.
The court that in the month of April of this year you have submitted the accounts
from 2019
annual return.
Yes.
Nothing has been submitted.
All right.
My lord. Let it be adjourned to 9th, my lord.
I will adjourn it to 9th.
Yeah.
Don't worry.
9th, I'll go.
On 9th, you will,
yes.
If necessary, you will file an affidavit.
Yes.
There is a order for hearing also.
We will hear it. We will hear it. But I am more interested in knowing whether he has complied with the direction or not.
He has not complied.
If he doesn't comply, then our consequences will follow.
I filed the application.
Sri B.N. Samantrai, Learned Counsel appearing for the appellant, requests for adjournment, which is opposed by Sri N.K. Sahu, Learned Counsel for the respondent. It is further submitted that despite being despite being appointed as a receiver, the appellant has not submitted the annual returns as directed by this court by order dated 4/9/2019. Sri Samantrai requests for some time to obtain instructions in this regard. Leaves this matter in the week commencing 9th September. The appellant shall satisfy the court that he has complied with the order passed by this court on 4/9/2019 in letter and spirit. Sayyidina will consider those other applications for substitution.
I have no objection if the
no, so I am deliberately keeping it. And right from the beginning you said that you have no objection.
No, I have no objection.
Substitution says nothing.
I am interested of disposal of the
no, true. But you see, the judicial order was passed by a coordinate bench, so it has to be respected. That's all. My anxiety is that.
Yes.
Thereafter, we'll go for hearing. Yes.
So item note 22.
Pass over.
So item note 23.
Pass over.
So item note 28.
Yes.
23.
23. Okay. It's for admission.
It's a reverse in judgment, and the appeal has been allowed in part. That is the subject matter of challenge in the present schedule.
You are the plaintiff?
I am the defendant number 1 and 2. And
defendant number 1 and 2.
Yes. State is other defendants.
There seems to be two first appeals.
I'm sorry.
There seems to be two first appeals.
2 first appeals.
Huh.
Reason being, this appeal has been allowed in part. And so far as rest part is concerned, my lord.
No, you can challenge only one appeal.
I have challenged in one appeal.
So what was the suit for?
This suit for declaration of right title interest, correction of ROR, and for permanent injunction.
Yes.
That suit is dismissed, for which appeal has been preferred, and this appeal is allowed in part. So far as rest part is concerned, this is allowed in my favor, and the portion which is not, which went against me, that is by the second appeal. And here, the facts of the case is like this.
No, what is the question of law? Tell me first.
The question of law is whether the suit is barred by law of limitation, and another point is whether once a suit has been dismissed for default, whether another suit is maintainable on the same cause of action.
That is fairly well settled. I think that is settled, well settled. Our technical ground will not operate as res judicata.
No, my lord, here, Order 9, Rule 9 application is, my lord, should have been filed. And in the statute itself, it has been mentioned that once a suit is dismissed for default, restoration provision is available. And in that provision, my lord, it is also mentioned that no further suit is maintainable. So this is not, in fact, maybe a technical error, but when special statute is there and special provision has been mentioned in the provision itself, my lord, this will definitely create a bar. No second suit is maintainable.
Then,
and
what was the finding?
But the finding is that in respect of some plots.
No, finding of the trial court.
Trial court is that once your suit has been dismissed for default, no suit is maintainable, no further suit is maintainable. And this suit is dismissed for default in the year 1968. And in the year 1995, by the successors of this predecessor, they have initiated.
So limitation and Order 9, Rule 9. These are the 2 points.
2 points. And third thing is the ground by which you are deriving your title over the suit land. You fail to prove that your predecessors have derived title from the CSROR. So this is how 3 points are there. My very important ground is once Order 9, Rule 9 application has not been revoked in the year 1968 by the predecessors, their successors are right now stopped to initiate another suit on the same cause of action in respect of the same law.
All right. Heard serious case upon trial and counsel for the appellant. There will be improved judgments considering the grounds and considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. We'll take only 2 and 3.
My lord.
2, 3 and 4. Okay. No, 4 ta hai jo ye.
My lord, this question of law, so far as point of limitation is concerned, my lord, that has not been written here.
2 and 3 lekha hai ji, 3 lekha hai ji.
Limitation point.
3 lekho na thi apuno.
My lord, I am arguing on behalf of Mr. Pardon.
3 lekha hai ji, whether the lower appellate court is justified in holding and coming to a conclusion that the suit is not barred by the law of limitation. Lekha hai ji ko?
Yes.
है on the following substantial questions of law लिख ले से page 11 रे 2 और 3 तक लिख है ना तापर if you notice to the respondents by registered post returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR, list this matter
7th October.
November को
Then we come 18th November.
18th November. Yes, Mr. Samatra, 18th November.
My lord, so far as IA is concerned, my lord, status quo in respect of the suit land.
Is there IA? ये कितने? 23 though. 531. IA 531. All right. IA notice as above. There shall be status quo as regards the suit property shall be maintained till the next date. Yes.
Okay.
So that on 28.
Yes.
Wait, please, Your Lordship. This matter relates to 4 tanks.
4
tanks, water reservoirs. And this is in Kolahandi district. Well, the petitioners are the one family who are actually the entire village covers. But this is not a representative capacity suit. This is sued by the persons who say their ancestor excavated those tanks for the purpose of irrigation purpose. And it is they who are to enjoy the same, but the public are also enjoying it. Like the water is used for irrigation, fishery and other things. 62 actually government took over the tank, transferred in favor of the Gram Panchayat and deprived the petitioners to use the tank.
1962.
62. Means they actually transferred it. Still they continue to enjoy it. Subsequently, when they were prevented, they filed the suit. Suit was long back, in fact. The suit was filed for declaration of right and interest. This includes the fishery right and everything. So trial court rejected on a different ground. Appellate court rejected on a different ground. Trial court said that you have not established your right to the property. It was a Gaunti property. And the Gaunti had lost his right after the Gaunti Abolition Act. He said after abolition also, as per the Village Police Abolition Act, the Gauntia retained some property in their favor.
Village police na village officers?
Village police, village officer, 2 acts are there.
No, village officers act we got
2 acts are there.
Yes, yes.
So that was our stand that we still enjoy our right over the property in question. Therefore, they cannot be deprived.
No, say that if you can please highlight. That office was itself abolished.
Abolished.
Office of the county.
Right.
So where does he acquire the power to grant this?
The user of the tank is a constitutional right rather.
The user is a question of title.
Article 21 or 21 says right to livelihood. To use the water for agriculture purpose, for drinking purpose.
No, sir, maybe to that extent you are correct. But what about the title? You are claiming title simply on the basis of...
also is meant a right.
Okay.
They actually clogged it in this way.
Okay. Then what
Appellate court said that is a Order on Rule 8 has not been complied with, as if it's a representative suit. And they have also said the suit is otherwise hid by the provisions of OGLS Act. The OGLS Act no application to this. So both the courts below gave finding in a different way, but resultant is dismissal of the suit.
What are the substantial questions of law you have framed? Let us see.
So let's kindly turn to just 1 second. But page 11, let's kindly see.
Page 11 of the appeal memo. Appeal memo. Yes. Yes.
These are the issues framed.
Yes.
Findings are at page 12. Exactly what I have narrated for Lordship. But page 14, the appellate court says there is no definite description of the suit land. Page 14, word. The description is vague. There is no plots are there. If a one plot is there, entire plot, question of description doesn't arise. Next, he says section 42 is a bar on article 64 and 65. So nobody claims adverse position. So kindly then turn to page 15. He says order on rule 8 is a bar. Section 7B of the OGLS Act is a bar. I don't know how the court has arrived at such findings. The substantial question of page 16. Sir, B, C, and E are the three grounds.
B, C, and E.
E. There is no question of vesting. There's abolition of Gauti right.
Yes. All right. Let's see. SP Mr. Leonard, Senior Counsel with. Yes, what is your name?
Sakshi Rao.
With Ms. Sakshi Rao. And counsel for the appellant. Appellants for the appellants. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 16, B, C, and E. Issue notice to the respondents by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. All for the LCR. List this matter. November.
18th November.
The week commencing 18th November.
Great.
What injunction status quo?
Okay, sir.
IA.
IA is there.
What about this dispensing with filing of certified copy? You have filed.
I think
I'll grant you 4 weeks time. 4 weeks time. IA 247 of 2020. 4 weeks time is allowed to file the certified copy of the judgment. Yes.
So right now 31.
Ma'am. In this case, my lord, the agent appellant is the plaintiff against a reversing judgment. That suit was filed in that year 2012 for recovery of sum of rupees 70,000 towards area rent from defendant from 1/7/2009 to 35/2012. And another relief pendant light and future interest and damage. My lord, that plaintiff's case is that, my lord, that plaintiff purchased a property from one Jaja Purohit, who was the recorded owner. So after his death, his legal heir, my lord, annihilated in his favor. So defendant was a tenant under the original landlord. So thereafter, my lord, he accepted the plaintiff as landlord and he was tenant under him.
Was there any agreement or oral agreement?
No, oral. So he is a tenant that is not disputed because, my lord, when he didn't vacate, my lord, I filed a case under Section 5 and 7 House Rent Control Act. So in that case, he has said that I was not a tenant. With permission of one of the co-owner, I resided, but that was not disputed because, my lord, that he lost in that House Rent Control Act. Then he preferred, because in that case, I filed two for fixation of area rent and eviction. Fixation of area rent was allowed, but eviction that was disallowed. So two appeal was preferred before district judge. House Rent Control Act jo appeal अच्छे division कलो just तार dismissal that appeal his appeal was dismissed, my appeal was allowed. Then I preferred I filed education case. In that education case, he filed a Section 47, and that was over because ultimately he lost in that and confirmed that he was a tenant. But in that this present suit, I filed a suit for recovery of parent right for a limited period because the barred by limitation beyond 3 years. ମୁଁ ସେଇଟା ପାଇଁ ଗୋଟେ କଲି. Trial court decreed that suit, but appellate court said that when that earlier House Rent Control Act court has already confirmed that 100 rupees per month, so you cannot enhance. Your lordship may kindly see that finding. Trial court to sabu mo favor तथापि trial court रो गोटे कहि दोछि. Your lordship may kindly see page 19 of trial court judgment. Your lordship got it?
Yes.
Plaintiff's claims area house rent so and so 2000 pendant let for the period so and so. As for the case, the suit house was asset at the rate of 100 rupees by the council and HRC case number so and so. Then, in spite of under house rent control, it is difficult under the it is vacated, did not vacated, so nor paid house rent to them coily, and it is decided. Then it is settled by him the cost of the residential house to the similar facilities in that vicinity at 2000 per month. So the claims of the rate of 2000 per month for the proceeding 3 years from the day it was the claim. Admittedly, there is no agreement. And the immediate agreement between the plaintiff and defendant regarding one rent, neither the pleading of the nor in evidence in parent so and so any notice was issued to the defendant. So then your lordship kindly to page 20. Last trade, then he was a tenant. But issue number 2, your lordship kindly say the important. Issue number 2, plaintiff's claim for pendant let and future rent of interest at the rate of 2000 per annum from the date of birth. Then second para, from the evidence of PW1, it is revealed that the suit house consists of a Latin so and so, so and so. Then your lordship towards last, my lord, page 21. Page 21, right? Fair rent at the rate of 100 rupees per month of the suit name was assured by House Rent Control in 1984. In the circumstances, the rent of suit house at present will be 2000 per month as claimed by the plaintiff cannot be disbelieved in view of the rising price of all the goods. Further, the rent of the residential house with similar facilities in the suit house and so 1 month is pleaded, and it is specifically denied by the defendant in his written statement. He has not denied that the monthly rent of suit house will be 200. So he has not denied. Therefore, my lord, trial court decreed my suit. Your lordship may kindly see the page operating portion, page 23.
Yes, yes.
Page 23.
All right. Then what happened?
Then your lordship appellate court finding, your lordship kindly see. Appellate court कहले जे you cannot enhance कहीं ना already fixed by house rent control. In that in 84 it was fixed at 100 rupees. Therefore, when my execution in the meantime, my lord, in the execution stay hela 47 hela, so I could not recover my money. Therefore, for the 3 years I filed this present suit. So in present suit, my lord, I claim that arrear on the pendant let and future interest and damage. The damage was refused by trial court. Therefore, my lord, your lordship, kindly see the finding of trial court Mugutti Khalpoduchi, page 45. Page 45 of lower appellate court judgment.
All right.
Your lordship. Towards last, but
All right. I'm admitting it. Admitting it on question number 1. Question number 1.
Question of law, your lordship.
Question number 1. I'm admitting on question number 1.
Your lordship.
1 and 3.
1 and 3. 3 was the occupation charges in view of
Sumitra Mahathir, learned counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 8 लिखाई 1 था मैंने आई
और 3.
Issue notice to the respondent by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter. November.
18th November.
In the week commencing 18th November. Remaining matters will take it up on Friday. Yes.
For your lordship, it's a small matter.
Yes.
If I can complete.
Yes. Item कितने?
34.
34. ये कौन जाने में जाएगी? आगे तो पास होता पर कौन खेलने में जाएगा? नहीं था मुझे तो कौन था? 31 पर 34 था. वे ये कुछ करने चाहिए.
Very good, sir. There's a reversing judgment.
Yes.
But a very interesting case of Barampur, in fact. The lady had 3 daughters.
Barampur more judgment नहीं था.
3 daughters and 1 son. She had about 110 decimals of land. Barampur, the Surasura Thai. She wanted to give it to all 4 children. So she executed 3 gift deeds. 3 gift deeds in favor of 3 daughters. 1 will in favor of the son. Rest of the land. That is 27 decimal each. The daughters were married. And one son is 29 decimal, the balance area. Subsequently, the daughters were there in their respective family place. Gift was accepted. And the possession was also delivered. Possession is the same family. So son with his wife and other in-laws prevailed over the lady to cancel the gift deeds. Unilateral cancellation of the gift deeds. The trial court found it has been acted upon and plaintiff sued for declaration of right title interest. 3 daughters confirmed and declared, and their possession direction was given. She allowed this son to occupy it with all the 3 sisters because there are cordial relationship between them. But subsequently it became shower. So son didn't vacate. So they also filed for eviction, like recovery of possession. Appellate court reversed it on the ground that gift, no possession has been delivered. But possession is not sine qua non. If a lordship looks at the 3 decisions are there. So 126, read with 123, 122, 122, 123 and 126. There is no question of possession. Once it is accepted, gift is accepted. Title passes. Therefore, the trial court findings are absolutely correct. The appellate court committed wrong in that, saying since they are not in possession, it has not been acted upon. Since the mother was in possession, therefore it was not acted upon, and the gift was disbelieved. Cancellation was accepted. He said cancellation is bad. Unilateral cancellation is not permissible. But intention of the party shows doesn't want to give it. That cannot be the basis to discard the evidence and value of the gift deeds.
Yes.
So that is the only substantial question of
What
law.
about the appellate court?
Reverse it. Page 23. The number 2, 3 and 4. 2, 3 and 4. One is also there. One is also there. We recital the document shows it is erected upon.
Third Sri SP Mishra, Learned Senior Counsel, with Miss S. Raut, Counsel for the appellants. Substantial question according to page 23, 1, 2, 3, 4.
Sir, the interim application, they should not dispose of the property.
LCR call for notice notice as above. As an interim measure, it is directed that no third party interest shall be created.
Or not to change the nature and character.
No third party interest shall be created in respect of the suit land, nor the parties shall change the nature and character thereof till the next date. See, November. Hearing. I have completed the list. And all the matters, some of the matters have been passed over. Those pass over matters, I'll take it up on Friday. Because tomorrow after lunch, I may not sit. We will take it up on Friday. It's already been passed over. List is done.